Good morning, good morning, good morning, amazing law nerds. It's Thursday, December 14th. I can't believe it. It feels like the holidays, but also like how the hell how are we here right now? I don't even know. I'm not ready. I'm not prepared. So, replay crew, love you. There will be timestamps down below. I'm going to give you a rundown of what we're talking about tonight. A little explanation of our members only live stream for those of you looking for it. We're going to talk about that in a minute. Yeah. So today we are doing quick updates on the TikTok psychic, the Young Thug trial, the Petito Laundrie civil suit. That might be a little bit of a longer quick bit. We're going to talk about the new Dobrik lawsuit. We're not doing a full deep dive. We're going to do a mid dive. It's mid. I mean, all things David Dobrik. It's mid. We're just mid. And then we are going to get into all of the new filings and updates with the texting judge, who seems to now be suspended. So we're going to talk about all of that. For those of you that are like, so a 4-hour stream, go ahead and place your bets in the chat on how long the stream will be. Emily, do you have any idea? No, I sure don't. It's just, it takes what it takes. Today was going to be kind of the last stream of the year, but I'm just not done yet. So we're going to stream on Tuesday, one more stream. And the stream on Tuesday is going to be a food court, because between like the Panera lemonade and the Mr. Beast D's Nuts trademark situation and updates with Beast Burger and the rest of it, and like, you know, all the things going on with Pete's, like Texas Pete's hot sauce, I just feel like we need to end the year with a food court. I might just grab a whiskey. Emily, you stream at 11 a.m. It's the holidays. Maybe we'll just put some Irish cream in the coffee. I don't know. We're going to get together. We're going to have a food court. We're just going to have a really just ridiculous food court stream together. More like a members only stream, less like one of these streams. And we're just going to do that. So that's what we're going to do on Tuesday. This mug was appropriate today. It is where the coffee went this morning. Yes, we're going to have a Law Nerd Christmas party. That's exactly it, Kendra. That's exactly it. We're just going to have a little Law Nerd Christmas party. Things might get a little saucy. I'll wear an ugly sweater. I'm here for it. We're just going to do that. Maybe I will tell a tale or two of Christmas parties circa the OG DA's office. There was an unhinged court Christmas party where people were fighting over a Hooters gift card. Maybe we'll just talk a little food court, tell a few stories, have a little time to just be together as a law nerds and talk about some cases that aren't so heavy. So I figured we couldn't just end the year without doing a food court. And maybe, just maybe, I'm deciding on what I want to do with the members only live stream. We're going to talk about that in a second. I'm going to grab an exhibit. I have an exhibity. We'll just do that. We'll do a Law Nerd Christmas party. We'll tell some stories. We'll have some fun. We'll gift some memberships. Me too, B2, not just B2. I will also give some memberships, and we'll do the things. B2, thank you again for the 20 gifted memberships. That's incredibly generous and kind. Thank you. So we will do all of the things. So that's what we will do on Tuesday the 20th, and then there will be some new audio only podcast for you guys to catch up, some quick bits, but then I will be taking some time off with the family. And during that time off, Travis has an assignment for school where he gets to do a presentation about a Supreme Court case, and he got approval to do the Bad Spaniels Jack Daniels case. I'm so excited. So he and I are going to be working on that project a little bit over the holidays. I'm so excited about it, and like unreasonably excited about it. And I'm not a parent that's like, tag me in on homework. I'm a parent that's like, I went to school like a lot. And you've already exceeded the level of math I completed. So good luck with that. This one, I'm like, buddy, I'm in. And I'm like, can we make photocopies of all the connect the dots to hand out to your entire class? Because I'm like, we have to work this amicus brief by mischief into the case presentation. I'm so excited. So we're doing that. I will also be resetting what we're covering, taking a look at what trials are coming up, and doing all of that. So it's a time for me to kind of reset for the coming year and really take a look at what we want to cover going forward, what cases I need to like wrap up and case closed for, and really take the time to reset. And that's really helpful to me. I think it's helpful to you. I've been traveling a lot. I've not had a ton of downtime. So I take, some downtime offline over this time with my family, because you know what? Life is short and I really want to hang out and play PlayStation and Nintendo Switch with my kids and not feel like I'm not prepping cases and streams the way I like to prep, and making sure that I am re-energized for the new year. I really just like the downtime. So that's what I'm going to be doing over the holiday, and I will keep you in the loop on the app. That's to say I'm not going on a cruise this year like last year. I'm not going away for the holidays. If something pops off, is it possible that I pop in on a stream? I will let you know in the app. Am I going to try to avoid it? Yes, because I'm going to try to take the time and the downtime and make sure that we are just refreshed and reset to bring you all of the coverage that I continue to do next year. And I'm ready for new live trials and to bring on some new cases that we haven't covered yet. And that takes a little bit of research time and lead time. And this will give me lead time to do that. So with all of this, I'm happy to see you guys. I'm going to roll the intro. We're going to get going. And I appreciate you. So tell me where you're coming in from. Tell me what you're drinking. I have questions. I have coffee. I'm ready to roll. Guys, it's good to see you. Law Nerds, let's roll.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the Law Nerds unite to talk about facts, not... Let's get into it.
It's good to see everybody coming in from all over the world in the US and what you all are drinking. All right. So last night on the members only live stream, a lot happened. And some of those things were reading books. So we read a book that was sent to me by a law nerd to the PO box called Everybody Sharts. And this led me to a ADHD rabbit hole of Mr. Hanky the Christmas Poo. And then I was like, you guys, we're gonna just play a clip of Mr. Hanky the Christmas Poo. By the time the members only live stream was down, South Park was like, no one shall see this episode. Now, do I believe that my use of Mr. Hanky the Christmas Poo while we were talking about Everybody Sharts was fair use? Yes, it absolutely was. How much time am I going to spend fighting with Paramount over the use of Mr. Hanky the Christmas Poo in a South Park clip that is up on the South Park YouTube channel? Not a whole ton. Could I spend time fighting it? Yes. Do I think I would win? Yes. How long would that take? Weeks. Because here's the thing about fair use, particularly on YouTube that has a copy content ID system. The fair use system, and we've talked about this in the Bungie case about how this can go badly. But in really badly, and how the system can be abused, we need to swing back to the Bungie case and see what happened with that. That case is wild. So with the Mr. Hanky clip, could I fight it? Yes. And do a response and all of that? Yes, I could. Fair use is a defense to copyright use. It's like you've used something that somebody else's copyright, and you are saying, yes, I have used your copyright. However, I have a defense to it. It's not infringement because it is fair use. It's not an exception. It's a defense, which means you can still be sued for copyright infringement, and then you have a defense to it, and then you have to go through court. I've talked about it when I covered the H3H3 Matt Haas lawsuit and broke that down. So could I fight it? Yes. Could I just clip it out? Yes. Did I just clip it out? Yes. Will it be back up for the members? Yes. Am I contemplating a way to make that available elsewhere or available in a different way? Maybe. But with the content ID system, with certain copyright uses, they can just take down the video while you are fighting it, and then you can fight it or you can clip the segment out. Since I referenced Mr. Hanky, the Christmas poo, I'm just going to put a link into the video so y'all know what I'm talking about, and then we'll go from there. So is it that annoying? It just is what it is. The content ID system with these large media corporations, they do it automatically. And so could you fight it? Yes. Is it worth all of our time and effort? No, I can just clip it. And so that's what I'm going to do. So that will be back. That will be back up. No, I'm not instigating a lawsuit over Mr. Hanky, the Christmas poo. No. Howdy ho. Will I maybe just sing Mr. Hanky, the Christmas poo on stream to see what happens? Maybe. But after the wonky donkey, I don't know if I want to sing anything on stream. We finished off the stream with a Christmas tradition in the members only, which is Hookers and Blow Save Christmas. It is a delightful children's book about a tow truck and a snowblower. I don't know what you were thinking. This is a book about a tow truck and a snowblower. So that's what was on the members. That's what happened on the members only. So the members only replay will be back up. And members, I will put a note in the members spaces when it is back up. So you will have it. For those of you that are just becoming members due to the generous gifts of our community from B2 and from Monuments of Speculation and from Edward and everyone else, if you have just become a member, that will be back up for you in a little bit. But sometimes with the members only, there was this one time when we watched a music video. There's been a couple. Sometimes the content ID system gets cranky, and sometimes I fight it, and sometimes I clip stuff out. It just depends. So sweetie, no, I agree. I don't think Mr. Hanky would approve of Paramount being like, meh. I mean, South Park was supposed to be irreverent and like, damn the man. And I'm like, and now you have become the man. But anyway, it was hilarious. So did I suffer emotional damage yesterday? Maybe just a little bit. Are we fine? Yes, we're fine. I bought the Hookers and Blow book for my husband for Christmas. It's hilarious. It's just a lovely story about a tow truck and a snowblower. So it's fantastic. So I'm certain Matt and Trey would have been on your side. The thing is, Matt and Trey don't have control, right? It's the company that has the licensing. Did you guys see this story going on with, oh gosh, I'm going to get this wrong, country music singer Combs? What is his first name? Damn it. Sometimes the neurodivergence doesn't help. Let's see. Luke Combs, thank you. This is kind of the same thing that just went on with Luke Combs. Thank you. Thanks, chat. This is why I live stream, because my brain doesn't always function properly, but I figure between the like whatever 5,000 of us, we'll get it together. So this is like the Luke Combs thing, right? Luke Combs has a company that helps do takedowns when people are using his name, image, and likeness. His response on social media was, hey, I have this company to do takedowns for companies that are like bootlegging concert t-shirts and stuff. Musicians make quite a lot of money off of their merchandise at concerts, more I think than they make off of ticket sales or venue or whatever else. Merch is one of the big things for touring musicians. So he said, I have this company or law firm or whatever that takes down companies making money off of my name, image, and likeness without licensing it. But that company went after a woman who's selling tumblers on Etsy. And he says that he had no idea that this company had brought a suit for him. And I absolutely believe him in him saying, I had no idea, because when you have a company that has license of attorney to go out and do these things on your behalf, you have to trust that they are going to use discretion appropriately and make sure that what they are doing isn't damaging your fan base. But they went after an Etsy seller who was selling tumblers with his name, image, and likeness. This was a fan creating fan merch. And so he responded on social media being like, I can't believe that they are going after her for use of name, image, and likeness and copyright. This is not what I ever intended them to do. I was trying to take down people selling, like, large scale selling concert t-shirts and merchandise and whatever. Manda the Witch said, tumblers on Amazon, not Etsy. Thank you. Synonymous. Amazon handmade. So it made the tumblers, was selling tumblers. Are you technically allowed to sell tumblers with somebody else's name, image, and likeness on them without licensing and permission? No, you're not. Is it something that Luke Combs wants to go after, where a seller is selling handmade tumblers that seems to be a fan? Is that what he wants to use his, law firm to go after? No. So it can happen. Like, if you're making Etsy stuff with Mickey Mouse on it, can you be sued by Disney? Yes. Do they always do that? No. If you are, making Bravo related merch, can you be taken down by Bravo? Yes, you can. Is that something that they spend their time doing? No, they don't. So are there these, stalemates where it's not okay, but also it's not something that people are going to go after, where it's not licensed, but it's also permissive use? Yes. So it's a balance there with things like copyright. So Luke Combs went on to social and was like, I had no idea they were doing this. I had no idea they were shutting down this particular woman's Tumblr shop, offered to pay her. She said she got an email about it, had no idea, and got locked out of her funding for selling them and couldn't access her money. And he's like, this is not what I intended, was to go after fans that were making essentially fan art, which, again, fan art for sale is different. And this is not what he wanted to do. So he's like, we're going to send some money. We're going to make sure that she doesn't get locked out of her account. This is not what I want to do at all. I hate that the company did this. My goal was never to go after fans. It's not okay. Like, this is not what I ever intended. But it's also a reminder that, yes, these things can happen. And it's really a balance. Same with, streaming video games. It's a balance. If you stream all music from Nintendo, could they shut your channel down? They might. And sometimes they did. So it's a hard balance, because technically, is it like, well, you're selling somebody's name, image, and likeness and things that are copyrighted? Yes. Is it something that he wants to sue over? No. And that's where the discretion comes in. It's like, could you be sued for something? Yes. Would you have a defense to it? Maybe not. Is that what you want to spend your time doing? Maybe not. Lots of people make fan art. Lots of people don't mind if their community makes fan art. And it really just depends on the person whose name, image, and likeness that it is. I believed him. I believed his response. I think that he was absolutely shocked. And he was like, now it's time to have another conversation with the people doing takedowns. Like, this is not what I ever intended you to do. But again, when you sign that over to people, it can happen. And I get it. There's a difference between fan art and bootlegging concert merch. There is a difference between that. So it is a tricky thing to navigate. One of my favorite bands, the Dave Matthews Band, allows people to record all of their concerts. There's an app that I love, DMB Hub, that tracks statistics and song lists and has a community, and it's literally everything, and I love it. But when people tape the shows, those go up on DMB Hub. Could the Dave Matthews Band be like, excuse me, you can't fucking just record all of our live shows and put them on an app and make them available to like everyone in the world for free? Could they do that? Yes, they could. Do they do that? No, they don't. They're like, yeah, share the music. The Dave Matthews fan base is still buying every live track that the band puts out. They're still like, yeah, but I'm still going to buy everything. I have a lot of the albums on CD, on on digital and on vinyl. So are the fans going to still buy things? Yes. Is it going to cut into the ticket sales or whatever? For Dave, they're like, no. So they allow it to happen. Could they shut it down? Yes. Do I see comedians that make you put your phone in a freaking Faraday bag before you even go in? Yes, because they don't want their their show released because it kind of takes away the punchline. So anyway, um that's what we're going. Chat. Emily, you like DMB? We had no idea. Do I talk about it too much? I can't help myself. Do we talk about it a little bit too much? But again, could the Dave Matthews Band have shut that down and said no taping? They could have. Did they choose not to? They chose not to. So it becomes just because you can doesn't mean you should. And again, with comedians, do I have any problem with that? No, because if they're performing the same set, I mean, who's the last person I saw live? Kevin Hart. If they're performing the same set in multiple cities, you kind of lose the punchline if you've already seen the set, right? But with music, it's a little bit different. And again, just because you should doesn't, or just because you can doesn't mean you should. So with all things copyright, it is a tremendously nuanced and gray conversation. And because it is not heavily opinion based, the problem is the defenses to copyright infringement are very, very subjective, judge by judge. So if you want a breakdown of what the different copyright fair use prongs are, I've talked about it on vidIQ's channel ad nauseum. I've talked about it in content here covering the H3 Matt Haas case. And so with all of that, there's a lot in the copyright world at the moment, from Mr. Hanky the Christmas Pooh to Luke Combs. So it just is. And I think he responded really well. And sometimes celebrities take a minute to respond to things. It looked like he just took his phone out and went, this is not what I wanted to happen at all. I am immediately calling the team that does this and shutting this down. This is not what I intended, and this is not the fan experience I want my fans to have. And that's a really important distinction. We're going to be talking more about this when in an intellectual property when we get to food court and talking about Mr. Beast and D's Nuts. We'll be talking, the entire show is going to be me and y'all going, but D's Nuts? Mia, we need to do an entire episode on copyright tattoo drama. There's a lot of it. What about the D Brand case, Defy case? I am going to be bringing up the case Defy D Brand case. I just have not had time yet. Don't worry. We will talk about case Defy and D Brand. So with all of it, I know there's other trademark drama going on or copyright drama going on. I don't have enough information to talk about it. So I'm not caught up. Sorry, y'all. Y'all are like, talk about this. I'm like, I don't know enough about this to talk about this. So another time, I will say that abusing the copyright system on platforms violates the platform's terms of use. And if people feel that's happening, they can complain about it. And the most egregious abuse of the copyright system on YouTube I have seen is outlined in the Destiny Bungie lawsuit. And Destiny went through in that lawsuit and lined out everything they did and everything they did to try to work with YouTube to try to fix the situation. So if you're really curious about copyright system abuse, the Destiny lawsuit is probably my most comprehensive coverage of that issue. And it's a really interesting, I think it's a really interesting case because someone else was trolling Bungie by abusing the copyright system, pretending to be the company. And it was wild because it caused quite a lot of messy damage on social media, and it damaged the community that streams the game and took down channels. It was a mess. It was absolutely a mess. So that's what's going on with that. If you're interested, the Bungie lawsuit really covers that. So we need to get to quick bits. Are you guys ready? Are you guys ready to quick bits? Are we ready? I'm ready. Are you ready? Where did I put my quick bits bumper? We're all ready. We're all ready to quick bits. Quick bits. I'm half ready for quick bits. Okay, so I have an update for you from the last hearing in the TikTok psychic lawsuit. My throat is just like, we're going to cough. Hold on. We're going to cough. All right. We have updates to the TikTok psychic lawsuit. For those of you that are like, Emily, what are you talking about? Look, I know some of you might be over the TikTok psychic lawsuit. I'm not over it yet. I'm not over it yet. I'm not done with it. I'm not over it. But this last hearing put me over the edge just a little bit. So we're going to go right to the docket and talk about it. For those of you that have not followed along with the TikTok psychic lawsuit, a TikTok psychic is alleged to have defamed a professor at the University of Idaho, accusing them of committing the University of Idaho murders that Brian Koberger has been arrested for and is, maybe going to trial for. We'll see what happens. That case is kind of like, The professor said, please cease and desist, accusing me of murder. The TikToker said, that looks like toilet paper. I'm not going to acquiesce to that request. A lawsuit in federal court ensued. The TikToker is representing themselves, and wildness ensued. The judge has never-ending patience in this case. The motions before the court at this time are a motion for summary judgment. The lawyers for the professor have said, hey, we sent out a fuck ton of discovery requests. I'm paraphrasing. You haven't responded to them. So therefore, you've deemed everything admitted. You've deemed everything admitted because you refused to answer these questions. Now, technically correct. You've failed to answer discovery. Ergo, your failure to admit or deny are deemed as admissions, which means that the summary judgment could be granted on those grounds. You could be granted on those grounds, and then the liability would be determined. Hey, you're liable for defamation. Let's go to trial on damages. I mentioned that the TikTok psychic is representing themselves, and the court has been quite patient, sometimes in a way that I'm sure is frustrating. You tell me if you find this frustrating. Here's what the court just did. Emily, where's your screen share? Not there. Folks, we're professionals. Am I looking at it? Yes. Is it pulled up? No. Still, good. Welcome to Pacer. It's a delight for everybody's eyeballs. Docket text minute entry for the proceedings held before the judge on 12/7/2023. I was going to be at that hearing. I could not because of other obligations. I was bummed. The attorneys and the TikToker pro se appeared. The court discussed deadlines which are forthcoming, as well as plaintiff's motion for summary judgment. The court extended time for the defendant to respond to requests for admission to Friday, December 15th. The court's like, you're getting one more chance. The positive motions deadline will be extended to January 12th, in which to amend the plaintiff's motion for summary judgment. The plaintiff requested reconsideration as stated on the record. The plaintiff's like, but your honor, you have said multiple times to this defendant, fuck around and find out. When are we at the find out part? Can we be at the find out part? Can we get to the find out? Because there's been a whole ton of fuck around. So the judge is like, we're going to give you one more chance to respond to this. So the judge has been incredibly patient. A lot of judges would not extend this grace, but because she is representing herself, she is receiving more grace than most would. This has not stopped the TikToker from going on to their remaining platforms and accusing the judge of all sorts of impropriety. And this judge has been able to look beyond that and say, the judge has said like 3 times, you need to follow the rules and deadlines. Like at some point, this is an adult, Your Honor. There's consequences. It's court. But the judge has said you need to adhere to all deadlines. They did not adhere to this deadline. And the court's like, you have till Friday. Well, I think the judge is protecting the record and being patient. I have known to be critical of judges that are overly patient. Maybe that's trauma, because I worked with a lot of judges that were the patient was not the word that would come up ever. I think the judge is waiting because at some point there is going to be an ultimate hammer drop in this case. I think the judge is building a record of patience for when there is a hammer drop. Docket entry order as stated during the 12/7/23 status conference pursuant to Federal Rules of Civil Procedure 36A3. It's ordered that the defendant shall respond to plaintiff's request for admission consistent with Rule 36 on or before December 15th. Failure to respond to requests for admission will result in the matters being admitted. Plaintiff may file an amended renewed motion for summary judgment by January 12th to account for any responses to plaintiff's request. All other deadlines remain in effect unless otherwise ordered. So the court is like, let me tell you what you need to do. So we will circle back to this in January and find out what happened. But yes, this is the part, Becky in the chat, Becky said the poor professor, she has to keep shelling out money. This is the part that's frustrating to me. This is the part that's frustrating to me with this case. The professor said, can you stop accusing me of murder on the internet? That's defamatory. Sent multiple cease and desist. And the TikToker was like, no. The professor then sued, because what else do you do in that circumstance? The professor sued. And after the professor sued, the defendant is like, I'm not hiring a lawyer. I'm not spending any money. And has just continued on and on and on with this. So the professor has to continue spending money to fight this. It is tremendously frustrating. And I can't imagine how frustrating it is. But I think the judge is building a record with this pro per to say, I have told them what they need to do. I have extended them grace. So is it fair to the party that has the lawyer? No, it's not fair to the party that has the lawyer. They are spending the money. They are having to go through things multiple times because the other party is representing themselves. And the judge has been exceedingly patient. It doesn't stop the TikToker from going onto the internet and saying that the judge is biased and unfair and the rest of it. This judge has been overly cautious with this pro per, in my opinion. But at some point, the hammer will drop. We're not there. So, that's the update with the TikTok defamation case. Let's go to the Young Thug case, shall we? That's where we're going now. So I covered the Young Thug RICO trial that's going on down in Georgia. This is a newer article from Business Insider because the criminal trial has now been paused. If there's one thing the judge in rapper Young Thug's criminal trial is sure of, it's that there's no such thing as a free lunch, at least not until deliberations. Hold on, let me see if I can. Let me move this over so the amount of ads. The trial expected to last up to 12 months. 12 months. It took 11 months to pick a jury. Like, not every single day, but it took them 11 months to get their jury selection. And one of the jurors ended up like in custody for 3 days for filming the proceedings. I mean, in addition to a defense attorney getting arrested, defendants picking up new charges for doing hand-to-hand transactions in court, a sheriff's deputy getting arrested and prosecuted for having a relationship with one of the defendants, and more. They are reporting that they are estimating this trial to last A year, which means from jury selection through verdict, this case could last 2 years. So even though I have seen the 6-month estimate quite a lot, this is a 12-month estimate. I don't fucking know at this point. My estimate is they're going to run out of jurors and end up in a mistrial. That's my estimate at this point. The trial adjourned for the holidays early after one of the co-defendants was stabbed in jail on Sunday and is unable to, appear for trial because he is not healthy because, stabbed. The judge told the jury Monday that a participant in the trial had a medical issue. The judge said nothing about whether it was a defendant. It could have been one of the attorneys. The judge kept it very neutral, so the jury did not know what was going on. A participant had a medical issue. Tuesday, he said the medical issue still exists and released them till January 2nd. The medical issue refers to the multiple stab wounds an inmate inflicted on co-defendant Stillwell Sunday night at the Fulton County Jail in Atlanta. It was the second time in 18 months that Stillwell has been stabbed while jailed without bail on the indictment. I don't know what's going on with that defendant, and I don't know who's mad at them in jail. But surviving getting stabbed in jail twice is a feat. Stillwell's lawyer told Business Insider that his client is recovering and he's allowed to visit him daily. He can't say more because of ongoing security concerns. Yes, if he's been stabbed twice, then there are ongoing security concerns. I imagine the lawyer is not pleased. So the judge had been asked by a juror. The man said in his request, feels like a long shot, but can we get like lunch maybe every 2 weeks or so? Remember, these jurors have gone through 11 months of jury selection. They are not at work. They are going to sit in trial for 6 months to a year. And this juror's like, could we maybe get lunch? Now, if you remember the Murdaugh case, the jurors got lunch provided by the courthouse every day. So he's like, could we maybe get lunch? I don't know how much they pay for jury duty in Georgia. I would be surprised if it's more than $15 a day. So the judge said, you've got a lot of nerve, man. You trying to ask me for lunch. Before explaining that Fulton County has quote unquote bad credit and he no longer has the money to provide amenities for the jurors. Now, a defense attorney was previously ordered in the case to buy lunch for everybody in court, and apparently bought lunch from a strip club that was nearby because this case is this case. But apparently the county cannot afford lunch for the jurors. The judge said, it's one of those things I wish I could provide you at this point in time, but I'm not in a position to do so. I can tell you that once you become a deliberating juror, I can make some arrangements for some sustenance. So let's see. Thank you, Smurfana, for Googling. Fulton County pays $25 a day, according to Google. So, however, by Tuesday when court broke, they are down to 15 jurors. They are down to from 18 down to 15 jurors. There's no, I don't see how they're going to get through this trial. They've already had issues with jurors being shown on television. They've already had issues with jurors' identities being discovered. They've now had a defendant stabbed, and they've already lost several jurors. Yes, you only need 12 to deliberate. However, there's only 15, and we've got they're like 2 weeks into the trial, barely. And you're down to 15 jurors. I think this trial is going to mistry. I don't know how they're going to get through all of the prosecution has 400 witnesses and there's 7 defense attorneys that are going to provide defense witnesses. I don't know how in the world they're going to hold on to 12 deliberating jurors for this long. It's fucking wild. And I don't know what the state's going to do if they get to a point where they lose 12 jurors. By the time they get down to like 13, they're at 15. By the time they get down to 13, y'all just start counting the days of how long it's going to be until they lose another one. Because jurors in this amount of time can get sick and not be able to come to court. And you can't pause trial if a juror has COVID for 3 weeks. They normally dismiss them. Family members can get ill. Caregiver situations can change. It's bananas. So I am keeping an eye on this case. Let me know if updating it in Quick Bits is helpful to you. It was not a well-performing podcast. A lot of people did not listen. So I don't know if there's a lot of interest in the case or if it's just the time of year. So I'm going to keep updating it in Quick Bits. You let me know. And just we'll go from there. Alrighty. So that is updates on the Young Thug trial. Let's go to the Petito Laundrie case. That's going to take a little bit more time on the Quick Bits. Do I have anything else that's quicker? No, that was the quickest. Petito Laundrie it is. Let's zoom. So, Petito Laundrie. The last time we checked in with this case, the Petito attorneys had filed a motion seeking to compel co-defendant Stephen Bertolino, the lawyer, to disclose conversations that Bertolino had with Brian Laundrie before Brian Laundrie's death. The response from Bertolino was, that's literally the definition of attorney-client privilege. So no. A hearing was set for those motions on December 20th. I was going to cover that next week. It was going to be like the one thing we covered next week with that live hearing. However, at the end of last week, beginning of this week, days are weird. On December 11th, the Petito Schmidt attorneys filed a notice to withdraw the motion to compel the testimony of Stephen Bertolino. They're like, okay. And I don't know if they were like, yeah, I see your point that it's attorney-client privilege, or if they were like, this isn't worth fighting. I don't know what happened that made them just suddenly withdraw that motion, even though there was a hearing date set. But that hearing date has since been canceled and removed from the calendar because of the withdrawal of the motion. So because of all of that, Christopher and Roberta Laundrie both filed amended responses. And those amended responses deal with the new allegations about the conversations that they had with Brian Laundrie. So there was a complaint, and then there was a second amended complaint. Zach. The second amended complaint included the things that were learned in deposition from Roberta and Christopher Laundrie, saying that Brian Laundrie had called them frantic and said they needed a lawyer and the rest of that. I covered that on another stream that we will link down below later. So they've now answered that amended complaint. We're going to take a look at the answer real quick as it goes to the parts from the updated amended complaint, if that makes sense. So, all right. This is, whose answer is this? Christopher Laundrie's. They're essentially the same, Christopher and Roberta's. I kind of glanced through them yesterday. Could there be slight differences? Maybe, but they are essentially the same responses. They're the exact same length, et cetera, et cetera. So we've gone through quite a lot of this answer. With respect to allegations contained in paragraph 8 of plaintiff's third amended complaint. It's the third amended complaint, not the second amended complaint. My bad, and apologies. Defendant admits that defendant Stephen Bertolino acted as an attorney and therefore agents for Christopher Laundrie and Roberta Laundrie. That's a big admission. It goes a long way towards trial. I had asked when I did this coverage before, because Roberta and Christopher Laundrie, the Laundrie parents, had waived any attorney-client privilege and talked about their conversations with Bertolino. And part of the argument here is agency with the attorney, and they're not fighting it. They're like, no, this was our attorney. So there's no fight over agency. They've admitted that he was the attorney. He's admitted that they were the attorney. There's no fight over this. It's all admitted. There's no need to prove that they were the lawyers. We're not going to see a contract showing that he's the lawyer. Nobody's fighting it. Everybody's like, yep, he was the lawyer. He was the lawyer. And I think for Bertolino, his defense is going to be, I'm their agent. You can't sue me, lawyer, for speaking on behalf of them. Sue them, not me. So I think that's going to be the argument at trial for Bertolino, which is a really awkward position for a lawyer to be in because his job is to represent the best interest of his clients, right? But how can he represent the best interest of his clients when his defense is literally, I was speaking on their behalf, so it's kind of on them. This is different than what we saw in Depp v. Heard, where Johnny Depp was sued for the statements of his lawyer. kind of the situation we're not seeing here. They're saying the lawyer was acting as an agent on behalf of Johnny Depp, so we're suing Johnny Depp for the things that the lawyer said, versus the lawyer was speaking in an interview with GQ, the lawyer was speaking as themselves, so sue the lawyer, right? This is different. They are suing the lawyer and the parties, saying that you spoke for them. So, continuing on, with respect to the allegations contained in paragraph 9, defendant admits that Brian Laundrie and Gabby Petito became engaged. Defendant admits that Brian and Petito set out on their trip together. Let's see. There's a whole bunch of denials. Defendant admits that Christopher Laundrie and Roberta Laundrie contacted Stephen Bertolino on August 29th for purposes of obtaining legal advice and counsel with respect to their son Brian. And then they've gone through with some more admissions and some more denials. Christopher and Roberta Laundrie, on the other, at any point in time other than a couple of meeting. That's an awkward sentence. Let's see. This defendant admits that there was no contact between plaintiffs on the one hand and defendants on the other hand at any point in time other than a couple of meetings in Nicole Schmidt's driveway, which occurred before July 2021. So the Laundries are trying to distance themselves from any relationship they had with the Petito Schmidts. They're like, we barely even know them. Like, we kind of saw them in the driveway. Because the Petito family has said, our kids were engaged and we knew each other. And the Laundries are saying, I mean, we barely had any contact and we kind of saw you in the driveway. Interesting. They admit that they were aware that the Petito family was searching for Gabby Petito. They admit that the Laundries went to Fort DeSoto Park with Brian Laundrie from September 6th to September 7th. They deny the remainder of the allegations. So this is basically, we admit some, we deny some, and they admit the things that they said in their deposition. So that's really the answer. They deny a lot of the intentions that go to the heart of this intentional infliction of emotional distress case. The defendant denies that on September 14th, the statement was intended to reach Joseph Petito. So they're saying that wasn't our job, blah, blah, blah. So a general denial with a few admissions. And that's where we're at. This case is set for trial next year. That will be televised. When there's a new hearing on the docket, we will cover that hearing live. And we will continue to cover this case as it continues forward through the system. I'm very interested to see if the lawyer, who arguably was acting more as an attorney than Waldman was as Depp's attorney. I think there's a strong argument for that because Waldman was giving interviews to media outlets not connected with a specific case. Bertolino was giving a statement to the media specifically with an ongoing potential legal case as he was representing the Laundries. It will be interesting to see if he's held responsible for what he said or if the clients are held responsible for what he said. This is not an easy case. This is an uphill. It is an uphill battle for the Petitos. I still think that the purpose of this entire case was to get answers. I don't think a monetary judgment is the goal here. I think answers were the goal here. So with all of that, when there's another hearing on docket, I will let you know. It will probably be a status conference. And then I expect that we will see motions for summary judgment. And then if those summary judgment motions are not granted, it will go to trial. If those summary motions are granted, it might not go to trial. But we do know depositions have happened. We do know that there's been a lot more answers. We do know that Brian Laundrie called his parents frantically and they arranged for an attorney for him. And I don't know if that helps the Petito family close the door and begin to heal. I don't know what that looks like. I don't wish that on anyone. I don't know what walking through that would be like. And I think it would be incredibly difficult, especially the betrayal here of we were going to be in-laws, you know? So I hope that the answers they've received have helped them at least have a why, have answers behind it. Sometimes that makes it easier to start to move on, but we will see. We will see what happens in this case. I'm going to keep an eye on it. We're going to continue talking about it because it is emotionally an interesting case when you look at like what are the obligations to speak, to not speak, where are the boundaries of right to remain silent. They're pretty far out there on your right to remain silent. What is obstruction, what is not obstruction? I talked about that in our last the last stream about this, so I'm not going to derail our stream today on it. But what is intentional infliction of emotional distress? What does the law allow for? What doesn't the law allow for? And where the legality and morality in this case diverge, because it is a difficult case. Like the feels on the one hand versus the law on the other hand, and the law on this case is not easy law for the Petitos in this civil lawsuit. The feels are on their side. The law is an uphill battle. So with all of that, are you guys ready to talk about David Dobrik? Some of you are like, who? I love this for us. Let's talk about David Dobrik. For those of you that are like, who? David Dobrik is a YouTuber. Was a very large YouTuber. I don't know. Is David Dobrik still making content? Chat? I don't know. I didn't know this had happened until H3 updated it. And I was really glad they did, because it's been on my list for 100 years to circle back to the David Dobrik, Jeff Wittek lawsuit. And the David Dobrik, Jeff Wittek lawsuit is over a stunt that they were filming in Utah that went horribly wrong. And Jeff Wittek got incredibly injured because he was being swung around on an excavator, and David Dobrik is alleged to have stopped that suddenly, but inertia being what it is, swung Jeff Wittek around, and he hit the side of the excavator and collapsed in the side of his skull. Almost lost his eye. He was incredibly injured. That spawned a civil lawsuit between Jeff Wittek and David Dobrik. And then that spawned a second civil lawsuit that is newer. So we're going to be talking about the first lawsuit and doing an update on what's going on the first update. And then the first lawsuit. And then we're going to look at the second lawsuit and talk about what's happening in the second lawsuit, because we cover insurance lawsuits here now. we have. Jeff Wittek did an entire series on his YouTube channel. He's also a content creator. He has a podcast. He did an entire series talking about what this experience was like. He did some members only content showing video of this incident. It is horrific video to look at, but it's all on video. It is chilling video. And Jeff has talked about what's going on with him, with his recovery, the medical bills, not being able to be on camera, not being able to work, the change in his appearance, the change in his neurological functioning because severe head injury, the change to his vision, the numerous eye surgeries, all the rest of it. So and you see the videos of David Dobrik being like, get on up there, we're going to do this. Keeping in mind, I think David Dobrik is currently like 27 years old. Then again, Mr. Beast is like 25 years old and did a Squid Game thing and seems to have a safety team and an HR department. David Dobrik is like, we can just do whatever. So lawsuits ensued. Shockingly, when people are incredibly injured. Here's the other thing that we are dealing with. We are dealing with California, whether or not David Dobrik, whether or not these were employees of David Dobrik's because they were filming with him, whether these were collabs, whether there was actually business structure in other scandals David Dobrik has been involved in. He did a odd apology video talking about not having any HR, not having any process, not understanding the power he had as a massive YouTuber. There's been a lot of conversation about him and the Vlog Squad and running what was probably a multi-million-dollar YouTube channel. I imagine he was making upwards of potentially $1 million a month at his height, and having no safety or protection for those in his videos, not always paying those that were in his videos, being like exposure, stuff like that. So with all of it, chat, no, he did not use a ukulele. He did not use a ukulele in his apology video. That's true. Irene said, I remember watching David Dobrik videos with my kids thinking this will not end well. Accurate. I think all of us could see that. But unlike traditional media, traditional filmmakers, he had no protections in place. He had a lot of yes people. So when he was like, do this for the video, they were like, okay. So David Dobrik was sued by Jeff Wittek regarding the injury. We're just going to do a quick update of where we are with that. David Dobrik answered that lawsuit back in September of 2022. This lawsuit is still ongoing. We're going to just circle back with the Wittek versus Dobrik suit before we get into the other suit. Here's we just saw a Florida response. California allows for general denials. This is the response to the lawsuit. We deny. Nope. And then the affirmative defenses, which is all of the nope. So all of the affirmative defenses that you list, it's basically boilerplate, failure to state a cause, unclean hands, superseding, intervening, competing negligence. If you want to see a good breakdown of contributory negligence and assumption of the risk, Attorney Tom, who's a catastrophic injury attorney or catastrophic injury lawyer, did a really great breakdown of assumption of risk, contributory negligence, and what that looks like in injury cases. Because with this stunt, it's like, well, Jeff Wittek was participating in the stunt until David Dobrik then took it way too far. And so how does civil liability play out when there is some assumption of the risk, knowing that David Dobrik doesn't regularly operate excavators or whatever the large piece of machinery was, et cetera, et cetera. So he did a great breakdown of what that looks like in context of a civil lawsuit and apportioning liability. Remember, in a civil lawsuit, we saw this in the Paltrow lawsuit, you can attribute liability in portions, right? So if they found Gwyneth Paltrow was kind of at fault in the ski collision, but not all the way at fault, they could have said, oh, she's 10% at fault. So if she's 10% at fault, then we reduce how much she receives by 10%, et cetera. So there are these very deeply legal concepts of contributory negligence, assumption of risk, et cetera, that can come into play here. Tom did a great job breaking that down. I broke it down in the last Dobrik video. Unless you guys are deeply interested in assumption of the risk and contributory negligence, I'm not going to get into it too much more today. But again, there could be some apportioning of fault, but the person who's over 51% at fault is generally the one that loses. But they could say people are 50-50 at fault. Like in like a car collision, they can be like, okay, well, you didn't put your blinker on and that car hit you because they didn't stop. You both fucked up. Like both of you are wrong. So they can say 50-50 at fault. You both will walk away. You're both, everybody go. So this is all of their affirmative defenses. This is boilerplate affirmative defenses. It's literally just holding the place for affirmative defenses. There was much question about whether David Dobrik was represented by Johnny Depp's law firm, Brown Rudnick. No, they are being represented by Friedman. And I think it's Friedman and somebody. Friedman and Tittleman LLP. So different attorneys in Los Angeles, not Depp's attorneys in Los Angeles. I know there was a blip for a second on the interwebs talking about that. So there have been 2-minute orders. There have been additional dates set. The trial date has been set for next year. It was set for August 4th, 2023, and then it got bumped back. And these are the updated dates. Now, let me make this bigger without trying to make anybody motion sick. So let's get to updated dates. This is probably still dealing with stuff. We're going to find out. The trial date in this case is currently set for December 19th, 2023, with a final status conference of December 5th, 2023. The parties have conducted discovery, but certain discovery issues remain to be resolved. It's on video, though. The parties have sought to schedule depositions of plaintiff and defendant, but have been unable to because, among other things, parties would like to resolve all key discovery issues prior to the depositions. It sounds like they're all like, we need more stuff. One of defendant's key counsel is unavailable as she will be on maternity leave during the current time. Sorry. At the DA's office, they'd be like, give it to another DA. You're on maternity leave? I'm sorry. Another DA will take that case. We're going to keep moving. The parties have met and conferred and cooperated as to deadlines and discovery. The parties seek a trial continuance to allow plaintiffs and defendants to resolve discovery. Defendants intend on pursuing dispositive motions once discovery is done. The party, which means summary judgment. The parties have not previously asked for a continuance. The trial date is set for the 19th, status for the 5th. Please continue, and the court granted that. So this has been continued to when? I do not know. There are no dates. So this is not done with discovery, but there is now a second lawsuit involved. So what's going on with Jeff Wittick versus David Dobrik? Discovery. They're in discovery. And then we will get to motions. When we get to summary judgment motions, we will go through those. They're going to have a lot more of the facts discovered after depositions. That's going to be probably 4 months out, maybe more. So let's look at the other lawsuit, shall we? Because now there are two. So David Dobrik has been sued again. And again, I saw this because it was covered on the H3 podcast. And a lot of you are like, dude, David Dobrik's being sued again. And some of you are like, who? What now? But it's not just David Dobrik being sued. Jeff Wittick is also being sued. So State Farm, like a good neighbor, is suing David Dobrik, David Dobrik's company, and Jeff Wittick and Dirt Gear Company, LLC. Dirt Gear's been removed from the lawsuit already. Pay no mind to them. We are not going to go through the entirety of the lawsuit today. We are going to go through the relevant allegations. And then if you want more of a deep dive, we will do that at another time because texting judge awaits us. So the basis is plaintiff, State Farm, issued a homeowner's policy to David Dobrik as the named insured. The homeowner's policy was in effect for the period from April 5th, 2020 through April 5th, 2021. And then they attached it. Plaintiff is obligated under the homeowner's policy to pay up to the limit of liability for damages for which the insured is legally liable if a claim is made or a suit is brought against the insured because of bodily injury or property damage caused by an occurrence to which the coverage applies. And then they define bodily injury. Jeff was injured. They define occurrences of property damage. All bodily and property damage resulting from one accident, series of related accidents, or from continuous and repeated exposure to the same general conditions are considered one occurrence. This generally covers things like, I don't know, somebody coming to fix something at your house and falling off a ladder, or somebody tripping on your rug and falling down your stairs or whatever. Those are the types of circumstances, though, that can extend beyond that. The policy has exclusions. Bodily injury or property damage arising out of business pursuits of any assured or the rental or holding for rental of any part of the premises by the insured, this exclusion does not apply. To activities which are ordinarily incident to non-business pursuits. So there is a business exclusion for this homeowner's policy. Plaintiff has also issued a personal liability umbrella policy. So there's two policies, homeowners and umbrella. Look, that you need business insurance if you are running a business. Plaintiff has also issued a personal liability umbrella insurance policy, and David Dobrik is named the insured. It was issued in 2018. It extended through 2020. It's attached below. Plaintiff, State Farm, is obligated under the insurance policy to pay on behalf of the insured Dobrik the damages that exceed the retained limit if a claim is made or a suit is brought against the insured for damages because of a loss for which the insured is legally liable and to which the policy applies. That includes umbrella for bodily injury. But again, when we're defining business, what do we think there is an exclusion for? There was no coverage under this policy for any loss arising out of insured's business property or business pursuits of any insured. What was David Dobrik's business? Making YouTube videos. What was he doing filming swinging Jeff around on heavy machinery? Making YouTube videos, which in the lead up, because Jeff et al. Were filming the lead up, when they talked about the lead up to this, what they were saying was, this is like the 2020 comeback video. This stunt in Utah is like the COVID comeback video. This was meant to be their big comeback video. Toya is ahead of the class. Toya, Gold Star. Would this fall under workers' comp? We're going to get there. But for it to fall under workers' comp, wouldn't David Dobrik have to claim Jeff Wittek as an employee? Do you think David Dobrik was treating the people in the Vlog Squad as employees? Paying them via W-2, giving them work time breaks? Do you think we were doing that? I don't think so. I don't think so. But do you think that Jeff probably was an employee? Yes. Do I think the entire Vlog Squad probably were classified and misclassified as employees? Yes. Did anyone in the Vlog Squad sue over being misclassified as employees because they were probably employees because they were like cast? And California changed all of its rules with independent contractors. But do I think that they were cast members? Yes. Did I talk about this ages ago when this all came up? Yes. Did anyone sue him for that? Not that I've seen. Where are the statute of limitations on that? I don't know. We're at the end of 2023. But do I think there were probably issues of miscategorization there? Probably. Do I think that's going to cost David Dobrik a lot of money? Yes, but it has cost Jeff more. No matter what it's cost Dobrik, it has cost Jeff more. Because again, this accident was just so avoidable. It was just so avoidable. Okay. I'm assuming that Jeff is included in the suit for State Farm because State Farm does not want to pay for his medical expenses. Exactly. State Farm you've gotten me, Ingo, you have gotten me back on track beautifully, and I appreciate you. Let us go. Sophia's asking, why is Wittek also being sued? Let us go. Let us away into the factual allegations from State Farm. On June 21st, 2022, Jeff Wittek filed the case that we were just talking about. The complaint is cast in one cause of action for general negligence. The complaint alleges that Dobrik rented an excavator from Dirt Gear Co. Dobrik allegedly was provided no training or instruction on how to use the excavator. Dobrik allegedly was not advised as to safety features. The excavator was taken to a Utah lake in Provo, Utah. Dobrik had planned his social media comeback. And hey, that's what I said. That's what I said. Emily, keep reading. Dobrik had planned his social media comeback and had solicited the help of several collaborators and independent contractors, including Jeff Wittek. So this suit is alleging that they are independent contractors. We will see. I think the state of California would take exception to that because they consider almost everybody an employee, and the law changed before 2020. The plan was to have Dobrik drive the excavator and have several people swing from the excavator with various accessories such as wakeboards. So people had been like on the lake swinging around. David Dobrik allegedly began soliciting people to get on the excavator solely using a rope and swinging around on the excavator. Bigger, more drama, more intrigue. Y'all, wakeboarding is boring as fuck. Let's make it, I don't know, more dangerous. Look, the content brain sometimes is real. And when people continue to have to outdo themselves, we end up with like a Paul brother in the forest filming and putting things on the internet that caused, the first Admageddon or whatever. When people continue to push the bounds with nobody saying, hey, maybe that's a bad idea, you can end up in really bad places. It's on a movie set. It's hard for me to talk about this after the Rust case. On a movie set, in theory, you should have somebody being like, this is a bad idea. But even that doesn't go well because we've seen the Rust case. Even then, it doesn't go well. And they had a safety coordinator who was like, this gun's totally empty. And somebody died. Okay. Several individuals tried this. People indicated that Dobrik was doing this unsafely. After the warning, Wittek was tasked by Dobrik with getting on the rope. Dobrik allegedly noticeably slowed the excavator down too quickly. I mean, it stopped abruptly. I've seen the video. Due to the alleged negligence of Dobrik, Wittek allegedly suffered injuries. I understand that State Farm's lawyers are lawyering. However, Wittek was injured. Defendant David Dobrik and Dobrik LLC tendered their defense in the underlying action to plaintiff. So Dobrik took this lawsuit. Look, lawyers are lawyering because the lawyers in this case are like, we don't have personal knowledge of this. Like, just because it's on the internet, we don't have knowledge of this. We haven't done discovery. They are lawyering ethically. But Dobrik took that lawsuit to his insurance company and was like, you got me? Because like, you need to defend me. This is a lawsuit for negligence. That's what my insurance policies are for. The same way that Amber Heard said, hey, I'm personally being sued for defamation. I have a policy that includes that. Are you defending my lawsuit? And then her insurance company defended the lawsuits. Now, those insurance companies are all fighting with her and themselves because she was found liable, but that's a whole separate issue. So Dobrik went to his insurance company and was like, you got me? So Dobrik tendered their defense in the underlying action to plaintiff pursuant to the homeowner's policy and personal liability umbrella policy. Plaintiff agreed to provide a defense to defendant Dobrik, subject to a reservation of rights based upon the provisions of the policies referred to above. Plaintiff State Farm contends that the loss is excluded. We don't have to cover you because it arises out of the business pursuits of State Farm's insured. Our State Farm is saying our policy excludes business activity. How the fuck is this not a business activity? Anyone? Chat? How is this not a business activity? Were there ever any criminal charges? No. Could there have been? Possibly. Were there? No. No. So is this a business activity? Filming a YouTube video comeback for your YouTube channel when you're a YouTuber? I think they have a strong argument to the affirmative. I don't think this is Dobrik making like a video yearbook of him and his friends. Plaintiff contends that the loss is excluded because it arises out of the business pursuit of the insured Dobrik. In addition, plaintiff contends the loss is excluded because Wittek is a person eligible to receive benefits under workers' comp. So they're telling Wittek, you need to go do workers' comp. I don't know what workers' comp will say. Workers' comp is going to be like, are you really an employee? At some point, the state governing bodies are going to get into this and be like, he's an employee. Could Dobrik then get hit with failure to pay payroll taxes and stuff? Could happen. I'm sure he's had those discussions with his attorney. Because if Jeff files under workers' comp, Jeff has to go through all the hoops of workers' comp, which suck. Anyone who's been through workers' comp, is that easy for you? No, it's not. Therefore, the exclusions cited above preclude coverage for any eventual judgment or settlement. So State Farm is asking for a declaratory judgment. Remember, declaratory relief is literally asking the court to declare. I do declare. They're asking the court to order a ruling on the facts. Court, tell us that we don't have to pay because this is a business activity. Legally determine that this is a business activity. Our policy excludes business activities and we don't have to pay. We need you to rule that. They're not seeking monetary recompense. They are seeking an order saying, yes, State Farm, you do not have to defend this lawsuit that Dobrik is going through. You don't have to pay for the lawyers. You don't have to pay for the judgment. This is similar to what's going on with the Amber Heard action, but this is earlier in the proceedings. State Farm is saying, tell us that we're out of this shit. Tell us that we're out. Tell us that we're out. So they have filed it saying we are out. Plaintiff contends that it is not obligated under the homeowner's policy or personal liability umbrella policy to indemnify any defendant for liability, damages, judgment, settlement, or recovery for punitive damages, which means State Farm is not going to pay Whittick policy limits or whatever to make this suit go away. Dobrik is going to have to pay out of his pocket to deal with this. Each defendant denies the contentions of plaintiff. The defendants contend that plaintiff is obligated to indemnify each defendant for some liability, damages, judgment, settlement, and recovery. And State Farm is saying, we disagree. So we need the court to decide. So they are now, all the policies are then attached. So State Farm is now in a lawsuit with Dobrik saying, you need to pay this out of pocket. And Whittick needs to go to workers' comp. That is going to be an entire morass of state wrangling. So, is Whittick trying to, or is Dobrik trying to avoid just settling this with Whittick out of pocket? I don't know. Did Dobrik say, hey, we'll just settle this for policy limits, submit it to insurance? Yeah, well, you don't have the insurance that Alec Murdaugh had. Alec Murdaugh's insurance was like, fuck, man, this dude is going to go to trial and be like, it's all my dog's fault and we need to pay limits. State Farm is like, no, ma'am. You have a personal liability insurance. And you know what you weren't doing? Personal shit. You were doing work shit. So you should have had a business umbrella policy. And if any content creators take anything away from today, talk to whoever you talk to about your insurance, about business policies as well, to cover business activities. Because your personal life and your business life, even if you are filming it, if you are filming your personal life and it becomes business life, you might need different insurance. So with all of that, Dobrik is being sued. State Farm's like, we're not paying for this shit. Like, are you fucking kidding me? You were swinging a dude around on an excavator. How is that covered by your homeowner? No. Nope. So, yep. State Farm's not having it. So with all of it, I think we're going to see I think we are not going to see a settlement in the Whittick-Dobrik case until this case is resolved. So I think these two cases are now going to play off of one another and slow down any potential recovery. So with all of that, are you guys ready to move on to the texting judge? Are we ready? Are we ready to just like... LD said in the chat, when you get homeowners, they ask if you run a business on the premises. Yes, they do. It's just Eddie. My husband is a workers' comp specialist and he just out loud. It's just Eddie's husband. Sue said, I'm probably the only person you'll ever talk to that had a good workers' comp company. I'm glad to hear it. I didn't at first, but when the company I worked for saw how bad I was being treated, that's amazing, Sue. I'm glad you had a good experience. It is hard. Savannah said, I work in business insurance. Workers' comp for California is specifically its own beast. That is a very generous and accurate statement. Jennifer said, so if you have workers' comp, there are times they still make you pay workers' comp on contractors. Yes. Are you all ready? We're ready for texting judge. For those of you that were not on the members only live last night, we have a new friend of the channel. Her name is Bonnie. Everybody say hi to Bonnie the llama. I told the members that I would share Bonnie the llama today and that we would do a llama cleanse to swoop us into texting judge. That's what we're going to do. That's what we're doing. Chat, I don't know. Bonnie whips her hair back and forth. She also twerks. She came to the P.O. box. I still don't know who sent Bonnie, so whoever sent Bonnie, Laundrie, thank you. She has multiple songs. But Bonnie does whip her hair back and forth and whip her hair back and forth. She matches the colors of The Office. She is a Zuru Pets Alive pet. There's twerking. Is there also a corgi? Yeah. No, there's a pug. There needs to be a corgi, but there is a pug. There is a sloth. There is another llama. Damn it, Bonnie. We were done. We were done. We were done. Bonnie, you wanted one more moment? Sure. Sure. So that's Bonnie. Bonnie was not done. Christy said that's a kid's toy. I mean, here. I still have the box in the office. Y'all, I'm gonna let you judge this for yourself. I unboxed this last night while drinking whiskey with a knife that made the members very nervous. Here's the thing with the back of the box, Christy. The back of the box has a very sastified illustration of Bonnie the llama, and it says, "Dance and shake your booty with me." So you could decide how you feel about that. So the encouragement is clearly to dance and shake your booty with me. To which I say, I'm sorry, Pets Alive. My spinal surgeon has said that my L5S1 does not move like this. Like we don't twerk anymore. I didn't used to could either, but spinal fusion. So that is this is the very sassy Bonnie. This is the collect them all, in case you were curious. This is not an ad. This was sent for shits and giggles. But I do think they need a corgi. I'm just saying. Do I think it's funnier for adults? Yes. So I do think it's funnier for adults. Emily, I can't twerk anymore. Look, true story. I was out with Adam, Up and Adam, and Jason ages ago when they were in Nashville. And I had been drinking. And sometimes, I don't know if this is your experience too, sometimes when I drink, in my brain, I'm like, I am invincible and 21. I am not. I am in my mid 40s. My body parts are in their mid 40s. Jason was a Cirque du Soleil performer, and I'm like, we need to dance. I could barely walk the next day. So when I think I can still drop it low, like it's hot, I cannot. The fact that I didn't actually tear a hamstring is impressive, but I definitely tried to drop it like it's hot. I mean, I also karaoke'd WAP later that night with Zach. It was could barely walk. And I'm like, I am going to injure myself dancing. Fuck, I am too old. I need to work out more. That was my takeaway. I need to stretch. I'm going to tear a hamstring. What the hell? I could barely walk. And the next morning I was like, Jason, I can barely walk. And he's like, but last night you thought you could drop it like it was hot. I'm like, no. I did drop it like it was hot. I am now fucking paying for it. Yep. Mm-hmm. So I do the fitness martial workouts. And one day I will again drop it like it's hot. If I ever attend any of the VidCon parties, maybe I will do that. Maybe I will not. Everybody's got their cameras out. I probably won't do that. That kind of dancing is left for no cameras. That kind of dancing is just for fun with friends. Let us continue. Let us continue. Louis said I couldn't drop it in my 20s. I definitely could before I tore my ACL. The knees were better before I've had all of the orthopedic injuries. Same, I love the fitness martial. I do too. Counterpoint, you can also move heavy objects. I can move heavy objects. I do that. I lift well. I do not drop it well. I could pick it back up though. With all of that, we need to talk about this unhinged shit that's going on in Oklahoma. Let's get all of our bags together, y'all. I'm giving out free drink tickets. It's the holidays, and keep your hands and feet inside the ride. For those of you that did not embark on this journey with us last time, there's going to be a lot of repetitive bits here. So I'm not going to do a full rundown, but for a quick road so far, a very new judge in Oklahoma, Tracy Soderstorm, has been brought before the Judicial Council for trial on a petition with multiple violations of the Judicial Code and the Oklahoma Constitution. Those violations include gross neglect of duty, gross partiality in office, oppression in office, and other grounds specified by the legislator. Those are the charges, if you will, on this petition. The allegations range from texting inappropriately during a murder trial, making fun of counsel, making inappropriate remarks on social media regarding cases she was overseeing, making inappropriate remarks from the bench to defendants, not actually being a judge and lacking any judicial temperament, as well as allegations of coercing male attorneys to sit for photos in a pink chair and then putting them up in chambers because she thought it would be funny. And then when these things were brought to her attention, it's alleged that she basically lied and complained to try to end run all of the responsibility that was coming her way, much like the meme of, look, here comes the consequence, running as fast as she can and lying. So the judge has responded, and there is now a second amended complaint, and we are going to go through today the responses and the second amended complaint. So all of it today. We are going to spend quite a bit of time with texting judge. And when I look at federal judges, like in the TikTok psychic case, and I get frustrated with their patience and professionalism, I remind myself that the alternative is so much judicial fuckery that I couldn't have written this as a plot to a book. Because what the fuck? There is so much fuckery in this. The audacity of a brand new judge to and I have read some judicial complaints for things we don't need to get into, but I have read some judicial complaints. I have seen judges get in trouble for lying about things like time off. I have seen judges admonished for the way that they handled a particular case. I don't think I have ever seen this many allegations all at once and in a very finite period of time. Like, you just became a judge. You're going to speed run getting elected as a judge and losing your job and potentially your bar license in like a year. Like no cheating, not like a dream speed run, like a real speed run, like a real actual speed run. So I can't go to Code Green yet. Yeah, then we have nowhere to go. We got nowhere to go. We got to wait. We got to wait till we get into it. Nocturnus said it was like 6 months. I think from the time she got elected, the time she got appointed to the bench, because you get elected and then you take the bench in January. So from the time she took the bench in January last year to January this year to January 2024, she might lose her job between that year. So, speed running, complete career meltdown, unlike anything I've ever seen. Let us dive into all of the fuckery and the audacity. We're going to need multiple tabs for this one because it's an answer. I don't know a good way to do this other than to just have multiple tabs. So we're going to be switching back and forth. I whip my hair back and forth. We're going to be switching back and forth because we need to go to the complaint and the answer. So stay with me. I will try to make sure I am describing if I am in the answer or the complaint, because we will have to switch back and forth between the two to make this make sense. So let's start with the answer. Respondent's answer to petition filed October 10th, 2023 comes now the respondent texting judge. Count one admitted. Count one is that there is paragraph 1, there is authority. So when it matters, I'm going to go back and forth between the complaint and the answer because they're not going to respond all the way in what the first or second thing was. So the second thing that the judge is going to answer is responding to this from the complaint or the petition. I'm going to use petition and complaint synonymously throughout this because my brain is going to do that. The respondent, Tracy Soderstorm, not Storms Bedore, Soderstorm, is now and has been a district judge in Lincoln County in the 23rd Judicial District of Oklahoma, exercising judicial power under the provisions of the Constitution and statutes of the state of Oklahoma, and at all times material to the allegations contained in the position. She was elected to the seat in November of 2022 and took the bench on January 9th, 2023, and was brought up on disciplinary actions on October 10th, 2023. 10 months. 10 months as a judge. I have questions about what she was like as an attorney. Her response, respondent texting judge, is without sufficient information to admit or deny the entire allegation as alleged, as respondent has not been provided with the Council on Judicial Complaints investigative file.
Excuse me, I can't respond to this if you don't give me the file. I mean, I know you're just alleging that I was like elected, but I can't respond.
Oh my God. Excuse me, I can't respond because I don't have the file. Respondent will seek leave to amend the response once provided with the Council on Judicial Complaints investigative file. This is what they said. They said that she was a judge. She was a judge in Lincoln County when she was elected and when she took the bench. And she's like, I don't have enough information. Fuck off. We're at number 2. This is 31 pages. Buckle up, law nerds, grab a snack. We're at number 2, and the texting judge won't admit when she was elected and when she took the bench because she doesn't have the file. 3. The 3 from the complaint is the respondent is an elected judge and exercises judicial power under the Constitution and the statutes of the state. The response. Respondent is without sufficient information to admit or deny the entire allegation as alleged because texting judge has not been provided with the file. Ma'am, I'm sorry. Do you not know that your judicial authority comes from the Constitution? Are you confused? You need the investigative file to tell you where the judicial authority for you to like sit on the bench comes from. She copy and pastes that answer for 4 and for 5. For 6, the response is no response needed. Let's go to 6 and see what 6 says, because her response to 6 was no response needed. Here's what the petition says for 6. The respondent's conduct giving rise to these charges based on the report from the Council on Judicial Complaints is set forth below. Just admit it. Yes, they do set it forth below. No response needed. Even the response is snappy as fuck. 7 is the same response about not having the file. 8 is the same response about not having the file. 9 is the same response about having the file. 10, 11, same response about not having the file. 12 is where it gets interesting. Let's go to the complaint on 12. Here's the petition complaint. After publicly regarding the respondent's excessive phone use during trial, the respondent had the security camera moved where she could not be observed. When the camera was subsequently returned to its original location, a black box was inserted to block out the bottom half of the viewing area so respondent could not be seen. The blocking was eventually removed. That's 12. That's what the complaint says. This is her response on point 12. Respondent is without sufficient information to admit or deny, needs the investigative file, will seek leave to amend. Respondent further states, when the security camera was initially removed, she was not aware of any publicity regarding alleged texting until the Lincoln County Sheriff, Charlie Daugherty, advised Daugherty, one of those, advised respondent he had provided the security camera footage to the district attorney, Adam Painter, who then leaked the footage to reporter Nolan Clay. Mr. Painter had requested the courthouse security footage under the guise of an investigation and was provided the potential evidence without a warrant, court order, or subpoena. Sheriff Daugherty, we're going with that, like Chris Daugherty from American Idol. That's what I'm going with. Sheriff Daugherty confirmed he routinely provided such potential evidence to the district attorney's office without a warrant, court order, or subpoena because Mr. Painter was, quote, a person of trust. Excuse me.
Excuse me, judicial counsel? The sheriff fucked up. Your Honor, it's on the sheriff. It's not me. Like, they shouldn't be doing any of this.
Yeah. So the judge has thrown the sheriff and the DA under the bus, rightly or wrongly. I don't know. There's more we need to know. But said, you can't just provide the DA with security camera footage. All right, 13 from the complaint. The pattern of conduct demonstrates respondent's gross neglect of duty. That's the pattern of, listed above. The conduct further demonstrates respondent's lack of temperament to serve as a judge, undermining public confidence in the independence, integrity, and impartiality and competence of the judiciary. And then it lists the canons of judicial conduct in the Constitution that violates, and then goes on to say the respondent's action giving rise to these charges appear more fully set below. The response to that is respondent is without further information without the file. The same is responded to item 14. Item 15 is admitted. Item 15 is the state was represented by District Attorney Adam Painter and Assistant District Attorney Ryan Stevenson. The defendant, Kristen Marzell, was represented by Velia Lopez and Greg Graves, Capital Trial Counsel for Oklahoma Indigent Defense. That was admitted. The next answer is going to throw more people under the bus. So let's buckle up. 16 says, 4 weeks prior to trial, the state filed a notice of endorsement of personal witness to include Dr. Ryan Brown, MD, as a witness. The defendant filed a Dobrik motion. We're going to talk about that in a sec. The respondent did not hear the motion at a motion hearing on May 30th, 2023, and took the motion under advisement following the jury trial call docket. The motion is regarding whether or not the expert can be heard at trial. These are generally things you want as an attorney decided before you select a jury, because how you select a jury might shift based on who the witnesses are. And if you don't know if this witness will be admitted as an expert, then your case might change. So this is regarding the Dobrik motion and the jury selection, saying that the state filed and the respondent did not hear the motion. So that's item 16. Here's what the texting judge responded. First, I don't have the file, and I'll amend when I get the file. But respondent further advises that she was unable to address the Dobrik motion prior to the jury trial beginning on June 7th, as she discovered in the late evening of June 2nd that the court clerk, Cindy Kirby, had tampered with the jury selection process. Who had jury tampering on their bingo card for this case? I didn't. The court clerk's name isn't even Becky. What did Cindy do? What? Excuse me, Your Honor? What the fuck did Cindy do? Also, Your Honor, I have some questions. Here's my question. On June 2nd, 2023, you discovered that the court clerk, Cindy, was quote unquote tampering with the jury selection process. And you reported this to whom? Ma'am, as an officer of the state, sworn to uphold the Constitution, who did you report that to? Who did you report it to? Why is this the first time we're hearing about this? What in the ever-loving fuck? I'm going to keep reading. Late in the evening on June 2nd, texting judge discovered, apparently, allegedly, that the clerk Cindy had tampered with the jury selection process by initially removing from the jury panel any potential jurors that resided in the Wellston area, removing a potential juror with the same last name as the co-defendant. You can't have someone on your jury that's related to you, ma'am. And removing a potential juror that the clerk court, the court clerk was deemed to be quote unquote out there. Now, I will just say, if someone shows up to jury duty inebriated or under the influence in some way, the clerk who brings in the panel can excuse them for later service. It is within their discretion to do so. Does it happen often? No. But if it happens, can they say, okay, so we're not gonna do this today. So we're gonna have you come back. Okay. Respondent was initially advised of the actions by her court reporter. Why can't I say court with other words? Damn. And then the clerk confirmed her actions when confronted by the judge the evening of June 2nd. And then you did what? Judge was advised by Kirby, clerk, Cindy, that she had taken this action in previous cases. Okay. Generally, you wouldn't remove someone with the same last name, especially if it's common last name. You would bring the person in and ask. But okay. Respondent consulted with multiple judges on how to address the jury tampering issue. The judge brought the jury pool tampering issue to the attention of the administrator of courts, Jerry Askins, and was instructed not to use the term jury tampering. Judge was further instructed that it was her decision to strike the entire jury panel or reshuffle the jury pools for any trials currently set. Ultimately, the entire jury panel was reshuffled and the removed jurors were returned to the jury pool. The clerk's office can shuffle the jury pool. They can't fuck with the jury, but before the veneer shows up, there are things within their discretion that they're allowed to do, including excusing people for absences, excusing people who aren't needed. I imagine if somebody showed up under the influence, they could remove them and be like, I'm going to postpone your jury service to a different day. Things like that. They're allowed to exclude people who aren't properly subpoenaed, things like that. But instead, the judge is like, okay, look, I didn't hear the motion because the court clerk reshuffled the jury panel. Ma'am, you talked to other judges about it, and then what happened? And then what happened? Okay. 17 is the same response. I need the file, and then I'll respond more once you give it to me. 18 is mostly similar. However, respondent will seek leave to amend when provided with the investigative file. Respondent further advises. Ma'am, who are you advising? The Council on Judicial Ethics? Okay. Respondent further advises the issue of the court clerk's jury tampering actions was not fully resolved until a jury was finally seated in the trial in the late evening of June 7th. How did it resolve, ma'am? This goes on with the similar response for the next while, where respondent is without sufficient information, without the file, and will amend on and on. Until we get to number 25. Let's zoom the complaint to number 25. Quote, the respondent overruled the state's objection and swore the jury. So this is still on the issue of the state saying we need to have the Dauber motion ruled on about our expert before we swear the jury. And the judge is like, no, I'm swearing this jury. And the state objected, and the judge was like, no, I'm swearing the jury. For all of you that have heard me talk about a judge that did not understand how peremptory challenges worked, and me losing my ever-loving mind being like, can you not swear the jury until we resolve this issue? And the judge is like, no, I'm swearing the jury. I'm swearing the jury. As a prosecutor, at that point, you're fucked. You can't appeal. You can't take it up on a writ. There's nothing you can do. Jeopardy attaches, and you were stuck. Nothing you can do, which is why the prosecutor is like, time out. Don't swear the panel. Let's fix this. Do not swear the panel. Because once the panel is sworn, the prosecutor has no other option. Zero. So section 25, the respondent overruled the state's objection and swore the jury. Her response is, respondent further states that Dr. Brown was excluded from testifying as an expert as he had no testimony to offer that would assist the jury in determining any fact in dispute. His only testimony was that he believed the child's injuries were consistent with abuse, which was not a fact in dispute. Further, I forgot that the homicide case was regarding the death of a kid. I didn't include that in my summary. Further, Dr. Brown was excluded from testifying as the district attorney had violated 2 prior discovery orders by the court related to identification and disclosure of witnesses. The district attorney had been consulting with Dr. Brown regarding the case since the summer of 2018. Then rule that before you swear the jury, instead of acting like a petulant child and being like, I'm not going to tell you what I'm going to do. And then swearing the jury and being like, haha, fuck you. Does it feel personal? Does it feel like this judge does not like this prosecutor? A little bit, to me. That's just opinion. But if you know, this is happening in 2023. If you know this has been an issue since 2018, just rule on the motion then. And just tell them no. Okay. Tell them no. The judge continues on with the same, I don't have sufficient information to respond until I have the investigative file, until we get to item number 31. Item number 31 is continuing on with the judge texting. Let's give a little context. During opening argument, the judge continued to praise the defense attorney by texting her bailiff, "Can I clap for her?" Referencing the DA's office, the respondent noted they're not used to going up against competent attorneys, implicitly dismissing the capabilities of the state's attorneys and the defense bar. When the DA began to question witnesses, the bailiff texted, "He's horrible," to which the respondent replied, "True." The bailiff replied, "Sucks." There's 4 S's. While a video was being played to a witness on the stand, the respondent remarked to the bailiff, "This shit is boring." Ma'am, you've been a judge for 7 seconds and you're presiding over the homicide of a child. I'm sorry that you're not entertained. What did you think this job was? Being a judge is boring as fuck. What? It has a ton of paperwork and a lot of decision fatigue. This shit is boring. Sorry. 31. While an interview was played, the bailiff mistakenly thought it was a video that the state had previously lost. Respondent texted, "They didn't lose this one, but they should have." The bailiff replied, "It doesn't help the state at all," to which judge affirmed by texting, "Nope." The judge's response to that is, respondent further states during the interview, the mother, Danker, co-defendant, admitted to beating the child with the murder weapon, a short belt with a large belt buckle. You were paying attention to that? This is the testimony that's going on while you're gossiping with your bailiff. The mother further admitted that the defendant, Martzal, had not been alone with the child or ever hit the child. What does that have to do with anything? And it doesn't make your behavior any better. What I think she's trying to say is, yeah, but I was right. Like, the mom is the one at fault. Like, I don't think this defendant's guilty. That seems to be what she's trying to say. This goes on with her standard, "I don't have enough information to respond," until we get to item 34. Item 34 says, well, let's back up to item 33. The respondent later texted, quote, "This is dumb," during the state's direct examination of a witness. The bailiff replied, "I just hope the jury doesn't buy his shit." The judge responded, "He looks constipated." And is that the oh shit look? Well, is he constipated or is he sharding his pants? What is happening, Your Honor? Maybe focus on the evidence, because if there's like an objection to the evidence, you're going to have to competently respond to that. And the only way you can competently respond to that is if you're actually listening with an open mind and you haven't made up your mind as to guilt or innocence. Your Honor. Item 34, the judge and bailiff refer to the co-defendant, who was to appear as a witness, as a liar at least 3 times while she is on the stand. Judge spent the majority of the co-defendant's testimony on her phone texting comments like, "Can I please scream liar, liar?" Ryan Blackhawk's like, "What the fuck did I just walk into?" Texting judge. Texting judge. We can go to Code Red. We can go to Code Red. I mean, it's the same Code Red we went to last time for this nonsense, but we can go to Code Red. Chat, if you're new, take a moment to the YouTube things. Help a girl reach her dream of telling my 11-year-old that I'm a real YouTuber because I have an M after my subscriber numbers, because that seems to be the threshold. So, go ahead and hit the like and subscribe and do the YouTubey things. Code Red is a delightful moment where we all say what the fuck together. I've granted the chat's motion for Code Red. We are going to Code Red. The bumper is flashy. If you are flash sensitive, the flashing will end when the music ends. It is a 8-second bumper. So we are going to Code Red in 3, 2, 1. We are red. Chat, I will entertain a motion for Audacity in a bit. I'm sure we'll get there. Right now we're at fuckery. We might get back to Audacity. Maybe we'll just go full Christmas and do red and green for both fuckery and Audacity. Maybe we'll get to both. So we're in the middle of this trial. The judge has lost all objectivity. The judge has determined that the witnesses are liars, and then they start talking shit about somebody's hairline and joking about whether they're wearing a wig or not. Ma'am, there's a lot of reasons people might wear a wig. Let's not. So the further information that the judge would like to add to the item 34 response is that the mother, Danker, admitted multiple times to lying while on the witness stand. Excuse me, judicial counsel. Like, I wanted to scream liar, liar, but like, she's totally a liar. And like on the stand, she admitted to lying. So like, what is the problem? Item number 35 is admitted. 35. When a police officer took the stand, respondent texted, "He's pretty. I could look at him all day." To which the bailiff replied, "Same, lol." To this item, the judge just admitted it. I don't need the investigative file. I still stand by it. He's pretty. Your Honor, the fuck? That is the moment. That is the moment that the judge was like, admitted. Everything else, I need the investigative file. I don't have enough information to respond. Oh, he's pretty. Yep, admitted. So yes, what this judge admitted to was when a police officer took the stand, respondent texted, "He's pretty, I could look at him all day," to which the bailiff replied, "Same, LOL." I wish I could say that this was the first female judge that I have seen objectify officers when they are in court. It is not. It can be tremendously uncomfortable in court when it happens, and most of the officers try to just laugh it off and be like, that was weird. So, yep. That's what she chose to admit. Ma'am. Well, if you can admit that, why do you need the investigative file to answer the rest of this? Just wanted to point that out. We're at item 39. She has more she would like to add. We're still in this same murder trial and the allegations. Later, this is item number 39 from the complaint. Later, the respondent offered her opinion to the bailiff that, quote, DNA excluded Marzal on the bed. No way they get guilty on murder. So that is the judge's statement to the bailiff, stating an impression of guilt or innocence before a jury has reached a verdict. She would like the judicial counsel to know, in responding to that the DNA evidence specifically excluded Mr. Marzal from the murder weapon. But her response reads, "But was I wrong, though?" Well, you're texting about the bed, and the bed's not the murder weapon, but okay. She then goes back to, I don't have the file, I can't respond, for a number of items. We're going to zoom until we get to the next one, where she would like the judicial counsel to know more. Did I pre-mark these? No. Should I have? Probably. We are now at item 80. So we're going to have to zoom a little bit. We've gone 40 items down. We're into another part of the complaint. On item 80, we're going to back up just a little bit. Respondent judge instituted a policy that all plea paperwork must be completed with a copy delivered to her chambers no later than Friday before the Tuesday disposition docket. The Lincoln County OIDS attorney, Thompson, mentioned to the judge that it was a hardship for him to prepare and deliver out of custody plea paperwork on the Friday before the disposition docket. The judge responded, "It's not you I'm worried about, it's the DAs. They have given me reason in the past to not trust them." Item 80 says, Melissa Missy Johnson is employed by the Oklahoma County Services as a coordinator based in Lincoln. Respondent has stated to other people in the courthouse that she does not believe anything Missy Johnson says. So this is a complaint that the judge has talked about other employees and been like, I don't believe them at all. Item 80. Respondent further states that Ms. Johnson has previously submitted altered drug test results to the court as evidence, resulting in a defendant's suspended sentence being revoked and the defendant being sent to prison. Ma'am, that's a crime. What did you do to report it? If you're telling me that Ms. Johnson submitted altered drug test results, what did you do with that information? She's like, well, I don't trust her. Cause she did this. Some dude got sent to prison because she submitted altered drug test results. And then what did you do to resolve that situation? Because if there's fuckery, dude shouldn't be sitting in prison. Right? What? That's a big allegation to leverage at somebody. She's like, yeah, I don't believe anything Missy says. Respondent further testified to the counsel that she's made unkind comments about Miss Johnson to the plaintiff, and she has concerns about Johnson's credibility. Respondent sought advice from other judges in the courthouse on how to get Johnson removed from her courtroom because she, quote unquote, wants her gone. On August 22nd, 2023, respondent screamed and pointed her finger at Missy Johnson in front of her supervisor, Tiffany Karam, because Missy Johnson assisted the court clerk in entering a court minute order at Judge Mueller's request for a case assigned to Judge Mueller. Judge Mueller revoked a defendant's pretrial release bond because the defendant violated the terms of pretrial release. Subsequent to the defendant being remanded back to custody, respondent contacted the clerk, demanding to know who authorized the revocation. So that is the end of that scenario. We are going to zoom a little bit to item 82, which is what we were just reading from the complaint. The judge further states that Ms. Johnson has informed the court that she was not required to provide defendants with notice or due process regarding matters pending before the court. Ma'am, and what did you do then? If you have somebody being like, due process, what's that? What action did you take? Because using somebody else's alleged bad behavior to be like, but I'm fine, is really not what we need to be doing. This is about you. If someone else is fucking up and like denying due process, what have you done to protect the defendant's rights as the judge? This judge is like throwing spaghetti against the wall of allegations. She's like, you think I'm bad? Listen to what all these motherfuckers are doing. Ma'am. Continuing on, Judge Mueller is now up for being thrown under the bus. The judge said that she advises that on August 22nd, 2023, while addressing a guardianship, respondent discovered that Judge Mueller routinely revoked defendants' bonds without a hearing or a request from the state of Oklahoma in violation of the defendant's due process rights. Further, respondent was advised by Johnson that Judge Mueller has delegated to Ms. Johnson the authority to determine if a bond should be revoked and is allowed to instruct the clerk's office of the bond's revocation in violation of due process and Judge Mueller's judicial responsibility. Excuse me,
judicial counsel? Let me tell you what Judge Mueller's up to, because if you have problems with me, Judge Mueller is literally violating people's rights. I mean, I never seemingly reported it to anyone or never brought it up, but now that I'm in trouble, all you bitches are going down with me immediately.
This judge is going to burn the entire courthouse to the ground. She's like, I'm taking everybody with me. You want to know about Judge Mueller? Let me tell you what. These coworkers are not going to be thrilled. I can only imagine what is happening in conversations among members of the bar in Oklahoma. Lawyers in Oklahoma, y'all all right? You okay? What is happening? Who's practiced before this judge? Look, I need to just reach out to me anonymously. I have so many questions. I want to know what when Judge Mueller read this, I need to know the response. Because I've told you the story about two judges in the courthouse where I used to work fighting over a district attorney's appearance. I was just talking about this at Christmas dinner with my friends. I was like, do you remember when this happened? They're like, yeah. I'm like, okay, good. It wasn't a fever dream. They both needed a particular DA to appear in their court. And they were yelling down the hallway at one another because there were courtrooms and then a back hallway. And one of the judges came into the other judge's courtroom while that judge was on the bench, which is like a huge breach of protocol, and somewhat disrespectful. Came in, unless it's like an emergency, came into the other judge's courtroom and was like, I need this attorney in my courtroom. You can't just keep this attorney here. The judge that was being petty had ordered the DA to stay because once that DA went to another courtroom, Then the judge whose courtroom he was in, his calendar was going to take longer. Everybody's trying to get done by lunch, right? Everybody wants to get done. They're like, if this DA walks out of this courtroom, I'm not getting them back till 2 p.m. And then my day gets fucked and I'm not letting my day get fucked. They're here. I'm ordering you to stay here. The other judge is like, you can't just order them to stay here. Your cases aren't ready. I need this DA to finish up my cases. So I need the DA down the hall. You can't just order him to stay here. And the DA is just like, hi, I have a lot of cases today, holding all their case files. And the judge who had ordered the DA to stay said to the other judge, what are you going to do about it? Get on a chair and fight me? The judge he was yelling at was like 5'3". So that happened. Do judges go at each other? Yes. Do they bump up against one another's stuff? Yes. But I was in court like, oh my God. Oh my God. What are you going to do? Get on a chair and fight me? Damn. We went to lunch that day. I was like, what is happening? And then I got regaled with these two fighting about other things, but especially when they are partner courtrooms, if they share attorneys and one judge hogs the attorneys all morning, then the other judge's calendar gets fucked because they don't have any attorneys to run their cases and they're sitting around twiddling their thumbs until 11 a.m. And then they're like, I can't finish my calendar just because you want to be done at noon. So there's a lot of tension, or can be a lot of tension, when judges don't work well together because they can very much impact each other's time. Who won? We all won because it was a spectacular day at court and they were pissed at somebody other than us. So when they're pissed at each other, I'm like, I'm so glad it's not me. I'm so glad it's not me. So there can be lots of struggle between judges. When judges work together well, they work together brilliantly. When they don't work together well, these types of things bump up, especially if they're perceived to be fucking with each other's schedule. I've had judges order me to stay. Like, you cannot go over to that court. You cannot go over to that court. You're staying here until the cases are done. I'm like, they're calling for me. It's like, I don't give a fuck. You're ordered to stay. It's like, damn it. I don't want to get held in contempt. But also, I don't want to, Your Honor, please don't make me the middle. I don't want to be the chew toy in this situation. It happens. It happens. It happens. So we are now to the judge. Who is the judge thrown under the bus? Are we keeping score? This judge has thrown the court clerk's office under the bus, an attorney under the bus, another judge under the bus. She's admitted to thirsting over one of the law enforcement officers without needing to review the file. Let's see who else gets thrown under the bus, shall? Oh, and the defendants. She was like, but are we wrong? So we are now to item number 86. We are still arguing about what Judge Mueller is up to. This is now a meeting dealing with what was happening. The complaint petition says, at the meeting, texting judge told the attorneys that she could not accept the plea because she reviewed the underlying VPO and did not believe it was still in effect, even though it had been ordered to remain in effect in a companion domestic matter, the protective order. She has something to say about that. She doesn't need to review the file for it. Texting judge further advises that she discovered that judicial officers were not following the law related to granting or denying victim protective orders, including entering a temporary victim protection order and never holding a final hearing or entering a final order. Excuse me, Judicial Council, all these fuckers are doing it wrong. And never holding a final hearing or entering a final order. Respondent further discovered judicial officers were allowing litigants to utilize the victim protection order statutes as a weapon in domestic litigation where they were not factually or legally supported. And the district attorney's office was filing felony charges for alleged violations based on invalid temporary protection orders. Your Honor, they're just like granting victim protective orders and weaponizing them. And all the other judges are doing it wrong, and I'm doing it right. And based on everything else I'm seeing from this judge, I have a really hard time believing that this judge is the only one in the entire courthouse doing it right. And if this is happening in a courthouse, A, it needs to be reported, B, it needs to be escalated, and C, the defense attorneys can also start to appeal things and be like, this is what's going on in this courthouse and it's a violation of process. But she can't just sua sponte be like, no, I'm not doing anything about it. Let's get to the next additional information that this judge would like to share with the Judicial Council. We are going to get to the issues of what this judge was posting on Facebook and whether or not a judge has a right to talk about cases that they're working on Facebook. The hearing on the state's notice, this is from the complaint, to introduce gang evidence, and the defendant's objection was continued until April 10th, 2023. Later that same day, respondent judge published on Facebook to a group called Girl Attorney Okay. Not like yay okay, but like Oklahoma. Girl Attorney Oklahoma. Quote, note to future self. Calling motorcycle gangs stupid and juvenile to a room full of gang members may get you on a hit list. End quote. You guys, she's edgy. And later responded to her own post saying, quote, one of these days I'll learn to be judicial. End quote. Yup, that's me. You want to know how I got here? The meme writes itself. One of these days I'll learn to be judicial. Ma'am, you're not going to have to. You're not going to have to. The Judicial Council is going to they're going to take that right off your plate. You can go back to posting on Facebook. Let's see what she has to say about item number 101 in her response. Item number 101 in his response. Respondent admits to making the Facebook post on March 24th. She's like, yeah, I said what I said. I was being cheeky. What? Also, part of the problem with the judge being like, hey, calling gangs stupid and juvenile to a room full of gang members, part of the problem with that is that she had not ruled on the motion about whether gang evidence was going to be admitted in a particular case, which means for this case that she was hearing, it had not been determined that this particular motorcycle club was or was not going to be considered a gang. So part of the issue is not just that she's posting about an active ongoing case, but part of the issue is that she is pre-ruling on a case that she has not yet ruled on by saying they're a bunch of gang members. Well, you haven't determined that yet. That has to be determined by evidence. So that is part of the issue with her Facebook post. You guys, I'm not like a regular judge. I'm like a cool judge. Like a TV judge. Look, ma'am, TV judges aren't actually judging. All the participants are paid and they waive their rights. You are not on television. She continues to say that she needs the investigative file until we get to item 106. More fuckery on Facebook. We're gonna back up to item number 105. After disconnecting a call with Banner to call the judge back with the names, the bailiff called Banner a second time to inform him that the in-camera request would be taken up April 10th, 2023 at 9 a.m., and that he should bring a written motion on the Rule 15 request and that all previous orders in the case were stayed. The attorney clarified that under Rule 15, future proceedings were stayed, to which the bailiff said no. All of her orders, including the bond, are stayed. The attorney concluded that respondent had predetermined she would not grant the in-camera request based on the statement. Item number 106 says shortly after the attorney contacted the chambers, she learned her post on the Girl Attorney OK Facebook group had been shared with him. Judge published a subsequent post that she was removing herself from the group. Yes, ladies and gentlemen, this is the type of judge that needs to go into a Facebook group to announce, judges aren't supposed to be in Facebook groups, to announce that she is leaving. She must be a delight on the internet. I have to tell you guys that I'm out. Thank you. This is not an airport. She was removing herself for the group because someone shared one of my posts outside this group. Apparently, this is not a safe place for a judge to be human. What had happened was that the defense attorney, let's just back up a little bit. The defense attorney was made aware of the Facebook post. The defense attorney asked for an in-camera motion, and the defense attorney was concerned that the judge had determined that the motorcycle club was a gang and had been calling them a gang when it hadn't been ruled on whether or not they would be deemed legally a gang for the case that they were involved in. So the Facebook post is the judge pre-ruling on a motion that was pending. And that's why all of this came up. And then the judge was like, you guys told on me. How did this dude learn about my post in the Girl Attorney OK Facebook group? You can't say anything on the internet. So let's see what else the judge has to say about that, shall we? Respondent admits to making the Facebook post and removing herself from the Facebook group on March 27th. The things this judge is choosing to admit are baffling to me. I said what I said. The judge was like, I said what I said. The problem for me, one of the problems for me, is that the judge is missing the fucking point. The point's not that she said something on Facebook. The point is that you predetermined whether or not this motorcycle club would legally be determined a gang. And then the defense attorney was like, so I guess you're ruling against me on this ruling. Can we have an in-camera hearing? And the judge was like, no, give me the names of who showed you this Facebook post. I want the names. Who snitched on me? The judge is like, it's not an issue of prejudging the evidence. It's an issue of snitches. Snitches on Facebook. Good God. So the judge is like, yeah, I made the Facebook post. I said what I said. I guess I can't be human. Ma'am, you know who you can talk to about your cases real safely? Other judges and your therapist. Chat, as always, you're flawless with your timing. Lanny said, name them. Name them. And from the complaint, I didn't reread this because this has aired. From the petition complaint, the judge said, after speaking with the judge, the bailiff called the defense attorney and said, judge wants names. She wants to know where you got that information from. Was it Rachel? The bailiff called the defense attorney and said, name them. Name them. Name them. Was it Rachel? I bet it was Rachel. Did Rachel tell you? Referring to Assistant District Attorney Rachel Thompson, the defense attorney confirmed that Rachel was one person that provided the information to him, but not the only person. Name them. And I love that they're like, I bet it was fucking Rachel, wasn't it? Dude, if it was Rachel, the district attorney, who saw the judge make an inappropriate remark in a Facebook group, good on the DA for bringing it to the attention of the defense attorney, who's probably not in the Facebook group, and being like, you need to know that this happened. That's what ethical behavior looks like. And the judge is like, name them. Who snitched on me? Your Honor, your behavior is the problem, not the fact that they told the defense attorney about your behavior. That's the least of your worries. So, we get to item 115. After they're arguing about Rachel, and then they need to have a hearing about the Facebook post and Rachel. The judge inquired of Judge Kirk how to handle the request to make a record of an in-camera proceeding. In-camera means in chambers. The judge advised to allow the court reporter and to be consistent between the in-camera and courtroom requests. Before hearing the in-camera request, respondent told Judge Kirk she was going to deny the request. Item 115, respondent was provided a copy of the criminal bench book at the 2022 Judicial College. Section 37.1 of the Criminal Bench Book provides a checklist for many issues related to court reporters and specifically recites 20 O.S. I said that weird, 20 OS section 106.4, which provides that the refusal to permit or require statements to be taken down and transcribed by court reporter is a denial of due process. So the judge is like, this can be off the record, and the attorneys are like, the fuck it can. The judge says that she is without sufficient information to respond, but will seek leave to amend on that issue. Oh, it was the one above, 115. Respondent further states issues related to recusals are contained in District Court Rule 15, and there is no reference to Title 20 OS 1064 or the use of court reporter during an in-camera hearing. So the court's like, actually, Rule 15 doesn't say that. Judicial Council. And they're like, we gave you the rules at Judicial College. Were you not paying attention? What were you doing during Judicial College? Moving on to item 124. More Facebook fuckery. In the middle of this hearing, we are now still talking about the motorcycle club. 4 other people in the room recounted that the details of the defendants' association in the motorcycle clubs was explained to her, and their concern that the Facebook post presented an issue with respect to her ability to be fair and impartial in their case. All 4 further recounted that the respondent denied the request to recuse herself from the case during the in-camera request because she stated she did not know their clients and had not made any specific comments about those clients, so there was nothing to suggest and she could not be fair and impartial. So other defense attorneys who had defendants who were part of the motorcycle club came to this judge and were like, we need you to recuse yourself off of this case made on statements that you've made on Facebook saying that you believe that this motorcycle club is a gang. You have made a legal and factual determination without us presenting our case. So item 122 says the judge's denial of the request is evidenced by the defendants filing motions to recuse. After conferencing with Judge Turner at the judicial conference mid-July, respondent filed a recusal in both cases in August. So the judge was like, yeah, my bad. Then we get to item 124. Since taking the bench on January 23rd, Judge has published various posts on Facebook in direct contravention of the advice presented to her at the 2022 Judicial College. On January 24th, 2023, respondent published a Facebook, a quote-unquote bloop. No, I read that awkwardly. Respondent published to Facebook, quote, blooper of the day, defendant on a motion to revoke. I test positive for marijuana, but I have my card. Clueless judge. Is that even allowed? DA and defense counsel in unison. No, it is not. My bailiff, laughing hysterically. I need to read the marijuana laws. End quote. You guys, I'm quirky. I don't know. Is marijuana legal in my state or not? Can I spark one up at a dinner party? Also Sutton. How many references are we going to get to the Real Housewives of Beverly Hills today? She's like, can we just have like a marijuana dinner? What? I guess I should, like, you guys, I guess I should know the law. Defendant, I tested positive for marijuana, but I have my card. Can you do that? You guys, it's quirky. I posted it on Facebook. The fuck? It's so bad. Only 47 days before publishing the post, Judge had received training at the 2022 Judicial College about issues with judges using social media and admonished them to refrain from this type of activity. On March 7th, 2023, defendant Judge published to Facebook that she, quote, filled in for another judge and did my first domestic docket today. Chat, for a domestic docket, you are dealing with all domestic violence cases. So, cases that deserve like serious and solemn consideration. The judge said, finally a subject I completely understand and can't possibly screw up! Exclamation point. Not sure if everybody would agree, but I think I passed. Quotation, end quotation. The counsel interpreted this to mean she agreed or believed that she had screwed up other cases. Ma'am, Being incompetent is not a personality trait. It's not cute. It does not make you interesting. This whole like, I'm just a girl situation on Facebook is offensive. It's appalling. And how do you have any respect for yourself, your job, or your entire career? You're a professional on the bench in charge of people's lives, their freedom, their liberty, and their constitutional rights. And you're like, I didn't screw this one up today. That's great. You are a criminal judge. What? I don't even know why you would make posts like that. Like, what validation do you need? Also, if you need that much validation from social media, perhaps a therapist at this point. I'm just saying. A therapist to have a conversation about why you are seeking validation from the internet about being adorably incompetent in a very serious profession. Respondent further states that she admits to making the Facebook post on January 24th, 2023. She's like, I said what I said on Facebook. This is what she's admitting. The Facebook post and that she was thirsting for a cop. She's admitted these things. She continues to maintain that she needs the investigative file. But as to item 126, she admits to making the Facebook post on March 7th. She admits to making the Facebook post on March 15th. She's like, no, you've read that correctly. All those Facebook posts are mine. Respondent further states that Associated District Judge Sheila Kirk has jurisdictional authority to hear felony cases. She's admitted that another judge has the authority. Okay. She continues to say that she needs to see the investigative file. We're not done yet. We're on to item 136. We've moved on a little bit. The section of the petition we're in now is responsibility to decide. And we are at, just kidding, I misspoke. It jumped. We are now in misapplication of Sixth Amendment and state statutes. Item 136. On January 17th, 2023, defendant Cullum appeared before respondent judge on a felony disposition in case number. The defendant appeared without an attorney because her lawyer was arrested and detained in the Lincoln County Jail. I remember this. And I was like, what is happening? We didn't look into it further, but I remember the defendant's like, excuse me. I have a lawyer, but my lawyer is like not here because she's in jail. Although her attorney was not scheduled for the docket that day, texting judge had her brought from the jail to the full courtroom for the docket on which her client was appearing. After satisfying her concern about whether the attorney maintained any client funds that could be returned to the defendant, court stated to the defendant, you are out and on bond, and so you do not qualify for indigent defense attorney at this point in time. If you wish to qualify for indigent defense, show back up on January 31st at 9:30 and you will be placed back in custody where you will qualify for essentially the public defender's office. Do you understand? So she told a defendant, you don't have an attorney because your attorney's in jail. But we're not going to appoint you a public defender because you're not in jail. So if you would like to go to jail, then I'll give you a public defender. That is not how that works. Plenty of people are out of custody and qualify for services of the public defender. Just because you're not in jail doesn't mean you can afford a lawyer. This The defendant returned to court on February 21st, 2023 without an attorney, and the judge stated that it was not her practice to give someone that is out on bond a state-appointed attorney. The judge said, quote, if you are out, you are capable of working and hiring an attorney. The judge added that if she was out on bond, she was capable of coming up with the money to get out of jail. That doesn't mean you can afford an attorney. But she has more to say about this in her response to the Judicial Council. And the Judicial Council is like, that's not how you determine whether someone qualifies for representation by a public defender. Whether or not they are in custody is irrelevant. Judge did contact the Oklahoma Bar Association about how to address Campbell's clients that were scheduled to appear on the docket. The respondent was advised by the Oklahoma Bar Association that Ms. Shelley Levacy was attempting to manage the cases of criminal defendants represented by Campbell. Levacy did not appear on the docket wherein Cullum was set. Excuse me, Judicial Council. I contacted the Bar Association and said, this lawyer's in fucking jail. What do I do? And then they're like, another attorney is working on it. And it doesn't mean she doesn't qualify for the public defender. Ma'am. Let's see what else she would like the council to know. As to item 147, she again says no response necessary. I just want to see what item 147 is. Item 147 is the list of witnesses that will appear before the court or the council, the Judicial Council, to testify. And it is a list of lawyers and judge and court staff that is quite long. It's pages long. As to 148, and 148 is what they are asking for, an immediate temporary suspension. Petitioner alleges that the circumstances giving rise to the foregoing facts against texting judge are in grave danger of continuing. There is no evidence the texting judge will voluntarily cease and desist in the performance of those matters which gave rise to this petition. There is an existing emergency justifying the trial division of the court on the judiciary of the state of Oklahoma to temporarily suspend respondent from office pending the determination of the proceedings in this action. Great and irreparable harm and injury will occur if respondent is allowed to continue in the capacity of judge. Her response to that is, respondent further states that upon receiving the petition on October 10th, 2023, respondent voluntarily suspended herself on the same day. Excuse me? I suspended myself. So, you can suspend me. So apparently the judge is suspended because she has suspended herself. Mm-hmm. Did she just stop showing up at work? What happened? Did she stop showing up at work? Yes, to the chat. Ashley's like, you can't fire me. I quit. Oh my God. I wonder if she literally just stopped showing up. Item 151 is the last item here that is no response necessary. This matter is referred to the trial division of the court on the judiciary of the state of Oklahoma. Okay. No response necessary. So that is the response of the texting judge. There is an updated petition. The updated petition, from what I have seen, filed on October 30th, contains the note at the very end of the petition. Let's go all the way to the end of this petition. Contains a note that the judge is in fact suspended. Where is it? Where is my... I clicked on the wrong one. So let's get to the updated relief requested. In the updated petition filed on December 11th. What day is it today? December 14th. So this was just filed. Relief requested. The petitioner alleges that the above enumerated acts by the texting judge warrant discipline by the court on the judiciary as authorized by the statutes and the Constitution. The petitioner respectfully requests that the court on the judiciary enter an order removing the judge from office as a judge with disqualification to hold any judicial office in the state of Oklahoma. So they have updated their response. Immediate temporary suspension. This item is now moot as a respondent has given written notice filed on October 10th of her voluntary temporary suspension. So they have gone above and beyond to say, yes, we would like to permanently disqualify this person from being a judge. This is not them seeking her disbarment. This is the Judicial Council seeking to remove her as judge. Could there still be actions against her license as an attorney? Yes. Is that what this procedure is? No. This is to remove her permanently as a judge. Absolutely fucking wild and unhinged behavior. The things that you think you're never going to see that come to light. I'm glad that the media picked this up, because otherwise we may never know that this was going on. It just, between Girardi and Murdaugh and Sandstorm, or whatever her last name is, Soderstorm, apologies. Soderstorm, I am concerned for the well-being of my profession. I identify as a YouTuber, not a lawyer. I think there might be more ethical behavior. I don't know. Where has more fuckery occurred? I have questions. Where is more fuckery occurring? On YouTube and social media? Or in some of these fucking courts? Girardi, we've got to get to the competency procedures soon. There isn't a ruling on that yet, but there's more. But the amount of legal fuckery that we have covered is so beyond appalling. And there is a standard of ethics. There is exams. There is school. I mean, most people can pick up a camera and be on social media. And so when they make bad choices, sometimes you're like, I need you to know better. But I get that you're learning. Once you have become a judge, I feel like you should already know what your ethical obligations are and take those seriously. Like, and take those seriously. There's so much. And I know that Peter and Rob on Lawyer You Know and Law and Lumber are both covering the stuff that's going on post-verdict in the Maya Kowalski case, with a juror getting like doxxed in court documents and shit. Oh, right. And ChatGPT lawyer. Did the bailiff lose her job? I believe the bailiff was removed from the court. I don't know if the bailiff lost their job. I can do, let's see. Let's get to Q&A, and I will do a noodly Google and see on that. Y'all can probably Google as well, but I will do a real quick noodly Google, a googly Google. We're going to go to questions. I've got questions. You've got questions. We've got questions. And I'll Google while we do that. Let's see. I suspect there was an issue. Let's see what the most updated article is. It says that the judge is suspended. Talks about her texting with her bailiff. Let's continue to investigate, shall we? Let's see. We've got the bailiffs. All right, now we've got the bailiff's name. And yes, for all of you that were shocked that the texting judge is 50, that's kind of an average age for newer judges, like in the late 40s, early 50s, because you generally need to be an attorney at least 10 years. So let me take a look real quick. And see if there is any note. I don't see any note quickly about what disciplinary action became of the bailiff. I might reach out to the reporter and ask if they know, because I don't see any reports on it. I imagine there was disciplinary action, but I don't know if the bailiff was terminated. So for those of you that are like, wait, the texting judge is not 20. The texting judge is 50. Yeah. There's not a lot of maturity there for a 50-year-old, said by somebody who is in their mid-40s. So yes, the behavior is very stunted high school, junior high school drama bullshit. but it's bananas behavior. So let's get to your questions because you've got questions. I've got questions. Risha asked if I could cover the Delphi case. I have not gotten into the Delphi case yet. It is on my list. The amount of onboarding for that case that is required is a lot, but there is a lot of legal nonsense going on, and I'm very interested in the legal nonsense that is going on. But it is going to take me some time to onboard because there is so much to know. I think we need to just clear this up real quick on this judge. Give me 3 seconds with with the judge, because I've seen some of you asking more about the judge, and I came across this yesterday, and we can just take a minute. This is the judge's website when they ran for judge. Tracy Soderstrom is a constitutional advocate. Man, Facebook aficionado. Oh, wait, I did that badly. Let me make myself a little bit smaller so we can see this properly. A constitutional advocate, a small business owner and rancher, and a veteran. Ma'am. Endorsed by both the county sheriffs. There's 2 sheriffs in your county. They do that. I'm committed to zealously following the law. This is her statement on her website that she paid for to run for judge. That is still up, so you know. I am committed to zealously following the law. I have built a small business based on compassion and serving others. In the military, I learned the value of service. Now my mission is to serve you as your next district judge with competence, experience, and ardent defense of the rule of law. Ma'am? My I have questions mug is empty, but it's not big enough for the Audacity to fit. I need a mega mug for the Audacity because it doesn't click. It doesn't fit. Those of you that are like, click about. Okay. Okay. About. Meet Tracy. She's a veteran. Following in the footsteps of her father and grandfather, Tracy joined the Oklahoma National Guard at the age of 17, vowing to defend our Constitution. Thank you to Tracy's father and grandfather for their service. Tracy, I've got questions. But you guys, look. She's feeding a cow. Come on. How do you not vote for somebody who's feeding a cow? Compassion. In her nearly 2 decades of legal experience, I have questions about that too. Can you tell me more? Tracy has represented the most vulnerable in our communities. Ma'am, you wanted to put people back in custody to give them an attorney. You were like, hey, if you're out of custody, you can afford a lawyer. What? Tracy has represented the most vulnerable in our communities. Compassion is at the forefront of Tracy's work. No attorney for you unless you're sitting in jail. Sure. Compassion is at the forefront of Tracy's work with the clients of her legal practice because she understands it's sometimes what they need most. You're talking shit about people on Facebook, though. Experienced. Tracy is the only candidate to practice before the U.S. Supreme Court. I'm gonna need some receipts. She is also licensed to practice before the 10th Circuit Court of Appeals. I mean, you just have to file the application. And with the Supreme Court, you also just have to file the application. The Oklahoma Supreme Court and all federal courts in Oklahoma. I mean, you filed. Yay for your paperwork follow through. Several of her appeals have made case law in a good way. In a good way. Loving mother and grandmother. Tracy and her husband David have been married for 26 years and own a cattle operation outside of Chandler. Tracy is a proud mother of 4, grandmother of 7, and a former foster parent. Ma'am, Ma'am? Are you talking shit about the 7 grandkids on Facebook too? Like, there are some life experiences here that would indicate that you shouldn't be acting like a junior high school student. And yet, are we done yet? No, we're not done yet. Wait, is the donate button still up? So you can volunteer. Is the donate button still up? Ma'am, your campaign was a year ago. This website should be down. This should at least be deactivated. Okay. Texting judge as a grandmother to 7. Okay. I have a lot of questions. I have a lot of questions. So that's texting judge. Yikes. We're going to get back to the rest of our questions. We just had to. What I love is that the news reporting on this, the image that they have from the security cameras is the judge like on their phone. Just not taking notes, not watching the procedure. This is somebody in custody testifying on the witness stand. Just hanging out on the phone. Yikes. Autumn, the ADHD RD, said I fell asleep before hookers and blow last night, but made it through sharts. So bummed we'll have to be replay crew. So that replay crew will be coming back for the members only live stream. Mr. Hanky, the Christmas poo, has our stream temporarily blocked in all areas, but I am in the middle of trimming that part out and then figuring out how to distribute the live stream to you. So it will be back up at some point. Can Dr. B pop in? I think that was regarding the Christmas stream. I will ask. I do not know. We have a lot of food court to get through. Completed my first semester in paralegal with all A's. Congratulations. Thank you for the inspiration to go into this path. Life isn't the OC. Law also isn't the OC, but it's never boring. That's for sure. I don't know what the judge was complaining about. The judge was like, this shit is boring. It's like, actually not. Call me Al. So good to see you. How about a quarterly Brittany Girardi, et cetera stream? We definitely need to circle back to some of the cases we've been covering for years. It's just been so long. It's been so long. Cheryl Ray said, I've had the pleasure of chatting for the past 3 years. Thank you, Emily, Team Baker, and family. Thank you so much. Ma'am, take your PTO with blessings. Medicated moment. Thank you. I will definitely be taking some time off. Again, thank you to everyone who gifted memberships. I appreciate you. Happy holidays to all the Laundards. Apparently, we're having a Christmas party on the 20th. I'm very excited. Edward, thank you for the gifted memberships. Hello to you and your Pawnerd. Drinking Dr. Pepper and watching from work sounds amazing. Yes, do a lawsuit. T. Yes, sue Paramount. Like, you have no sense of humor over Mr. Hanky, the Christmas boo. Have you seen what's happening with DWKT pod? The Do We Know Them pod. I've seen in the chat that you guys have been asking about it, but have I caught up on what's happening? No. As I said earlier, I don't know enough to comment at all because I have been A, streaming, B, trying to keep up on streaming, C, holidays. So am I up to speed? Not at all. Is that a rabbit hole I'm going to go down? I have no idea. I really have been a little bit too hyper-focused on Pokemon Go Sleep. Like very. Matt said, for the record, on the record, let the record show. Hello, Spiffy Legal Mumbo Jumbo Talkie sister from another Mr. Hello, Matt Bond. It's good to see you. Hope you have a relaxing holiday downtime. I will. Did you see the clownery over on Book Talk? No, I have not. I've been under a rock. It's that time of year where I tend to come on and do content. chat with you guys in the comments and like yeet myself back off of the internet. Call Me Al said I was summoned by 3 members, only music video references. Why are your copyright issues usually musical? Because the music match system is one of the strongest on YouTube, and that is the biggest issue. I think our first takedown midstream Call Me Al was inspired by you. Because I said, is it from the song? And you're like, what song? And I'm like, bet we're watching the Call Me Out music video immediately with Chevy Chase. So that is exactly what it was. We watched the Paul Simon Call Me Out music video on a members only live stream, and YouTube was like, negative. What you can't do. And I'm like, we're reacting. And there are musical channels that can react to videos. They generally do them as VODs. They have to upload them, and then they have to fight the copyright system, and then they have to get their videos up. So when you look at channels that do musical reactions, it takes them a tremendous amount of work to be able to get those videos up and out, because they have to fight through the system first and be like, no, this is reaction and commentary, which is allowed on the platform, but you have to fight through all the hoops because the music system for copyright it seems to be slightly different than the content ID system. It seems like there are 2, and the music system is just like, no. And so fighting that is a little bit more challenging. Fandom has been fighting copyright since the 90s, in my personal knowledge, possibly, but longer. Star Trek depends on their fandom greatly, so maybe not. Yes, it's a push-pull. Henna artists watching for fair use. We definitely talked about fair use earlier, quite a bit. Carol said, hi from cold Glasgow, Scotland. Can't believe I'm catching a live stream on my birthday. Carol, happy birthday. I hope it is like cold but snuggly. What is the Young Thug trial about? It is a very complex racketeering case, and I have a whole podcast on it from last week. So you can find that there. Google Bucky's Gingerbread House for food court. Okay. The Bucky's Gingerbread House has come up multiple times, so I will. How can jurors be expected to survive financially with a 12-month trial? I have no idea. I imagine it's part of why jury selection took so long, and you're going to end up with a jury with a lot of people that work either for large corporations that pay for jury duty, or people who work for the state, local, or federal government, which also pays for jury duty, because I can't imagine that you would not have jurors that aren't being paid. Death's Angel, thank you so much for that. Thank you for so much. I don't know if I'm being an advocate for Jeff. I mean, we just need to call out what's going on in the lawsuits. I mean, he was injured and shouldn't have been. And if somebody was behaving responsibly, he wouldn't have been injured. There's a lot of more conversation that can happen around that. But I think we've already had those conversations in past content. So again, when I saw H3 was like, Dobrik was sued again, I'm like, wait, what? Insurance. What is your P.O. box address? It is listed in the description of all of the videos, so it's down there. E-Bears had question, how was the equipment rented? Was it rented using a business account? I don't know that. To me, it's a business expense. Oh, I'm sure it was. I don't know if David Dobrik was separating his finances that way, but it was clearly being used for business purpose, but I'm sure they already have that. Drama Llama Bonbon is the best. This is the only drama llama we need, is Bonnie the twerking llama. How do Fred and George feel about Bonnie? They haven't been in the office. So maybe that's how they feel. If injured twerking with Bonnie, what insurance pays? Shit, maybe business. Not legal advice. First member chat, Ellie, congratulations and thank you. Laura or Lorray, but there's no accent, so I'm not sure, and I apologize if I get it wrong. All I picture is the song Drop Low and Sweep the Floor with it. On this side of 50, but I still got it. Get it. Get all of it. I definitely can't sweep the floor with it anymore. They should be able to wiretap too, since they're trustworthy. Yeah, I mean, yeah, just why not? It's like, yeah, we'll just give them access to everything and wiretaps. Why not? Stephen, I hear you. Absolutely. Oh, look, a whole year. Congratulations, David. Thank you. Thank you for being shiny, sparkly, badass role model. Thank you for the callback to my TED Talk. And I love your sweatshirt. I see the purple I have questions sweatshirt. You said pants a lot yesterday. I did say pants a lot yesterday. And good to see you. Anne said my mother passed in 2010. Yesterday, I got a summons for her for jury duty. Clerk asked her to appear and bring her death certificate. Got a Zoom call and showed the judge the death certificate. Now resolved. And these are the types of situations where the clerk of court needs to be able to remove jurors from the jury rolls without it ever going to court. But also excuse me, she can't appear. She can't appear. Can't appear. Hey, EDB and Law Nerds, love from Ireland. Thank you, Marie. Hello, Ryan. We definitely need a Code Brown for the bullshit. Code Red kind of fills it in. I don't know if Code Brown would be dynamic back in the office. I mean, I don't know how I feel about that. I am still a content creator. I'm very concerned about how good I would look if all the lights were brown. And I also don't know if the lights can do that. I mean, green, yes. We can get some green in there, but I don't know about, let's see, we can get these. Well, we can do red and green. I don't think brown is an option though. But we've got some red and green going on. We brought in the audacity. We will jingle up the lights for the holiday party. I second Ryan's motion for Code Brown. I don't think these lights can do Code Brown. Colleague was dismissed by judge. Colleague goes back to another courtroom. Judge threatens contempt for leaving without permission. Records checked. Embarrassed judge. No apologies for colleague. Jasmine, I am disappointed but not surprised. It's like, you may go. And then it's like, where the fuck did you go? It's like, damn it. You said I could go. Rude. Steven, this makes me want to just sit in courtrooms before elections so I can see how they behave before I vote for them. It's very fair. Judicial elections can be very difficult because it's very hard to judge lawyers that are running for judge and know if the lawyers that are running for judge are bullshit or not. You tend to have to look at who they're endorsed by and what other people have to say about them and ask, if you know any lawyers, ask lawyers that might have appeared in front of them. It's hard. I need to know how this judge became a judge. I lied on my resume. They were elected. And to be completely transparent about how judicial elections go, in a lot of judicial elections, people just vote based on the name. And they're like, okay. And then next goes job description. It's like, oh, okay. They're this kind of lawyer and this is their name. All right, sounds good. And that's it. Name recognition, and job description. Most people don't do any more research than that. Jacob said this judge's actions hurt the reputation of all judges in the state. Frankly, anybody in front of this judge has been harmed. I would love to hear what the attorneys have to say. Kayla said, makes me wonder what else will come out regardless of the judge's road to office. Also, it makes me distrust the legal system more. We need to trust it. Yeah, there's a lot. And this is, again, when I talk about cameras in the courtroom, if any of these judges' trials or court hearings had been streaming, this would have come up, right? You would have seen it. You would have been like, oh, what is that judge doing? This is another reason why cameras in the courtroom, I think, are so important, to be able to observe what's going on in court proceedings and to also make that accessible for all voters. Some people cannot physically get to the courthouse. Some people cannot take time to get to the courthouse, but they could watch proceedings if they were streamed on the court's website or on YouTube or whatever, and they could know a little bit more about their judges. This is why cameras in the courtroom are important. I mean, we have body cam footage on law enforcement. Why don't we have cameras in every courtroom? Why is it a problem? Hey, feds, what are you worried about? Why don't we have, or even audio? I understand that there can be problems with the cameras fucking around. But if all the courts, like Idaho's like, we'll just stream it ourselves. Wisconsin's starting to do the same thing. We'll just stream it ourselves. Great. Put up your 3 cameras like C-SPAN and stream it yourself. And if you stream it to YouTube and get monetized, put the money back towards the courthouse. Okay. Lil Blossom Fairy said, Emily, it was my birthday last week. And I think that's treated. I treated myself to the Law Nerd shop. I got a Facts Not Fuckery hat. Thank you for being amazing. That is one of my favorite things in the Law Nerd shop. And I hope you love it. And thank you for your support. I don't know if I'm amazing. I just try to do the things I enjoy doing and bring you all with me. And all of us are just like, ooh, fascinating. And here we are almost 3 hours later. Becca Has Thoughts says, in OK, the courts say, if you can afford bond, you can afford an attorney. Only PR bonds qualify to my knowledge. That generally is not the standard. And that's why the judges are that's why the Judicial Council is pointing it out that that's not the standard. Stephen, Janet, I'm compassionate. Also, Judge, did you see that receding hairline and wig? Yeah. I'm compassionate. This dude's sweating. Lindsay said, I have laryngitis and just wanted to say hi. Lindsay, I'm sorry you have laryngitis, but typing, we hear you just fine. We'll be replay crew for Tuesday. Kate, happy holidays. Bedazzled Nails, good to see you. Do we know them podcast needs help getting eyes on an issue? A lawyer is false copy striking commentary videos for clips and screenshots. The video regarding Bungie addresses false copy strikes. Amanda says, have you seen the lore in the Mortician situation? No. I see, to be perfectly clear, I have seen that there is a situation. I have not seen the situation, but I've seen like Marquis has a video. I don't know if Atuzi had a video. There's a couple, I've seen titles of videos and I'm like, there's something happening. Have I gone down that rabbit hole? Not yet. Have I tried the Ruffles queso chips yet? No. Are they good? Do I need to? Are they good? I will stand for. I will do that. Very important question, Captain We the Barmy. Emily, what does D for? What does the D stand for? Well, it depends on my mood. Sometimes it is danger. Sometimes it is dongle. Sometimes it is Disney. Don't sue me, Disney. It's a joke. I'm joking. When I'm on a Disney cruise, the D stands for Disney. But it's been a minute. So yes, but also it is my maiden name. Will we get Brittany next week? Next week is Food Court Rachel. It's going to be a minute before we get caught up on Brittany. But I have it on the sphere of getting caught back up. There's a lot going on with Discovery, but not a lot going on in court. So yes, we will get caught up. Just Call Me Hen said I missed the beginning and nodded off during texting Judge. That's okay. I hope it was a good nap and you were tracking your sleep for Pokemon Go Sleep. Thanks for Fourth Wing and Iron Eagle. Lauren K. Hamilton writes excellent fantasy smut, especially Anita Blake series. Thank you, The Lady in Black. For those of you that weren't on the members only live, we had an entire discussion of where to start with some of them. Been a fantastic 10 months. Love it here. Unseen King, I love having you here. Code Purple for Get the Fuck Out. Yep. We might need a level Get the Fuck Out. That could kind of be our mix of Code Brown. Like with this shit. I think Code Get the Fuck Out is very fair. Launard Soph, I really like that. Kraken Studio, the real booty, said, see email for Gossip Train art need sizes. Oh, okay. Screaming Goat Swoop for Beyond Audacity and Red. I mean, where is my goat? The llama moved my goat. I swear the llama's jealous of the goat. But Vincent Van Gogh is a favorite. Sue said, after my mom died, they said, prove. Took in her ashes. I love that. It's like, she's here. I have brought her, depending on the size of the ashes. I've brought her. Chat's like, we have an entire zoo. Yes, we do have an entire zoo. We do have an entire zoo. We say get in the sea instead of get the fuck out. That would probably be a code blue. We do. We have pickles. We have llamas. We have goats. We have unicorns. We're an entire morning show soundboard. Which is fine. Which I kind of love. I'm like, what are we? We're a music board. We're a morning show. That's what we are. The llama is my new favorite. Fair. We occasionally have cats, Nikki. Yes, we do. Food court is on Tuesday. We are doing a food court Christmas party for the law nerds. We are going to talk about all the things food court and hopefully have some laughs. We're going to talk about D's Nuts and Mr. Beast. We're going to talk about Panera Lemonade, which is a little bit more of a serious one. We're going to circle back to the other food courts that we have, to all the food courts we have loved before. We'll do a whole food court episode, and we will do we will do that on Tuesday. For all of our other topics, I will be circling back in the new year. It's part of what I'm going to be doing on the break. There are some cases that have had so much going on, it's going to take a minute. Some cases are just stalled in arbitration or discovery or what have you, and I'll make sure to do some quick bits summarizing those, so I am not leaving you guys with an open loop on those cases. And then we will talk about, and in the member spaces over the break, I will be talking about what cases I'm thinking about onboarding and bringing on, and looking at what's coming up for trials, what is getting covered. Let's say I enjoy the non-murder cases, and that's the balance, right? Some of the cases, especially in the criminal side right now, are almost all murder cases, I think, that we're covering criminally. And those are the ones that tend to have cameras in the courtroom. The civil cases don't tend to get as much media attention, even though we are enjoying following them. So I try to balance things that may have televised hearings and things that are legal and interesting and not criminal. So there is a balance between the two, and I am always constantly evaluating that balance between the cases that are serious and the cases that are not, and how we cover what we cover. There was a hearing today on Daryl Brooks. There might be more Brooks trials coming up. I need to look at when they set the trial date. But if Brooks goes to trial again, he's got multiple open cases for witness intimidation, for the domestic violence allegations, for bail jumping, and there's a couple others. If Brooks goes to trial again, we're absolutely going to be covering Brooks going to trial again. I see you, chat. You're like, no, but I want to hear the evidence in the witness intimidation stuff, because apparently the allegations are witness intimidation regarding jail calls made during that trial. So we will see what's going on. But doesn't Brooks have a lawyer? Today, apparently Brooks had a lawyer. A lawyer had been appointed a couple days ago from the public defender's office. So yes, Brooks should have a lawyer, but who knows what'll happen by the time he goes to trial. So if Brooks goes to trial again, we will be covering that. We'll be covering all of the Donna Adelson stuff. That is going to be fascinating. She was quite expressive in court. I imagine that is going to continue, because there's much. We've got Corey Richins. We haven't even seen a preliminary hearing or a whiff of a preliminary hearing on that case. We've got 8 passengers, which I think is probably going to plea. That is my gut. My gut response is I think it's going to plea. What else? There are others that are skipping my mind, but I cannot sign up. I cannot set up for like a year of a RICO trial with 7 defendants. So we'll keep doing those as quick bits updates. I can't do that every day. You guys don't want to do that every day. We don't want to do that every day. How far behind I would be. Koberger, I don't even know when. Koberger doesn't even have a trial date. I'm keeping up on the Tati case. Trial's set for February, but I don't know if there's going to be cameras in that court, and I don't know if I can afford to put cameras in that court just for us. But it's on my mind. We do have winery updates that we need to get to. I don't know if I'm going to cover Daybell. I will cover Sarah Boone. I keep waiting for it to get closer to trial so I can do like a summary of what's going on and then trial. And Sarah Boone just keeps like firing attorneys. So I don't know what's going on. Brooks has cases in Milwaukee and Waukesha. Yes. Corey doesn't have a trial date. So I don't know about that. Majors is in trial right now. I haven't been following it. So it's mid-trial right now. So Ticketmaster update. I will take a look. The Ticketmaster episode of the podcast, nobody wanted to listen to. So I truly, when episodes do not perform super well, I'm like, it's always my assumption that people just aren't as interested in that topic. So I try to weave them in. And we'll try to weave them in. So correction, Boone's lawyers keep leaving her. I mean, that's fair. The insurance case with Hurt is not done. We're going to do a podcast on that at the beginning of the new year for sure. So that's where we're at. But I love skipping between the kind of serious implication criminal cases, the audacity cases, the food court cases, and all the rest of it. And that's what we will continue doing in the new year. So, with all of it, maybe try a Canadian case with Runkle. They're not televised, and the documents are hard to access. Runkle has a much tougher time. The documents are hard to access. I still think we should just do a moot court episode covering Grandma got run over by a reindeer. maybe we'll engage in some of that fuckery for the Christmas party. We'll see. So with all of it, you guys take care of yourselves. It's good to see you. I love chatting with you. I know Runkle and I definitely need to watch Legally Blonde. That is on the list. And with all of it, Lawnards, be well. I have 2 last super chats and then I'm leaving. Chat, Rob will defend the reindeer facts. Soap and Clay said, heard the code brown combo earlier. If your LEDs are attached to Alexa, ask her to turn them brown. It is the prettiest pinky purple ever. Thank you. I don't think this office is because I didn't want my kids messing with the light. So I keep it sequestered, but I will see if I can ask my devices. That is a good tip. Annie, thank you for the holiday wishes. Y'all have a great holidays. Take care of yourselves, take care of each other, and be well. And give yourself the space and time you need this holiday season. If that is ever going to every party you want to go to, go. If that is hunkering down at home with a book, do it. Take care of yourself and do not feel bad for doing what you need to do. And I will see you guys in the next one. Bye, Law Nerds.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.